Hello everyone, a very warm welcome to the final marathon session of our CAIIB November December 2024 examination for the BRBL paper. So finally the day has come. Tomorrow is our examination. All these days of hard work, efforts towards the preparation. We have already completed the syllabus, we have practiced the MCQs, the mock test, we have also seen the case studies. Now, one last step that will ensure our 100% preparation is this complete syllabus revision. We today are going to have the complete syllabus revision. We are going to see all the important topics, the facts that are sure shot to be asked in the examination tomorrow. No need to go into the lengthy explanations or the notes. We just need to see these facts because these are the topics from where questions were asked and are going to be asked. So this is the final step, your final effort towards securing 60 plus or maybe more than that and qualifying your paper of BRBL tomorrow. So I'm asking you to give this one last effort towards your preparation, and tomorrow you will reap the benefits, you will enjoy the fruits of your success. So what we are going to do today is we are going to cover all the acts module wise. In the module A, we have two acts, then we have four acts in the module B, 10 in module C, and 9 in module D. We are going to see all of these acts in terms of the meaning, the year in which they were enacted, if there was a special statute. We'll also see the sections because sections were asked in the previous examination. So this video is going to be focused, or we'll say it is going to be exam focused. Everything that we are going to revise today is very important from the exam point of view. So final revision, very quickly join the session, share it with others, and mark your presence. Be active. If you have any doubt, any query, if you still think a topic needs to be discussed more, do let me know in the comment section. And this session will go on till we have finished all the 25 modules, all the 25 acts in all the four modules. So now, without any further delay, we will start with the first topic from module A, the first act, which is the Banking Regulation Act. So like I have said, I have put these acts in one or two slides, all the important facts, only the important facts. I have put them here. So you can also download the PDF and you can use it for revision tomorrow before your shift starts. So if we see the Banking Regulation Act of 1949, we already know this year. It is giving us the definition of banking under the section 5B. We are going to discuss the important sections because sections are asked from this act. So section 5B, which defines the most basic information of our paper. Banking means the accepting for the purpose of lending or investing deposits of money. So deposits of money, we can divide banking into two parts: accepting of deposits and then giving out this money or giving out these deposits in the form of loans or investment. This is banking, and these deposits should be repayable on demand. So these deposits will be either demand deposits or term deposits. These should be repayable on demand or otherwise withdrawable by check, draft, order, or otherwise. So banking means the business of taking deposits not from anyone but from the public after carrying on or after taking care like of the due diligence, KYC, AML norms. Then the banks accept the deposits. These deposits are later on given as loans or they are invested. Loans on interest. The definition of banking tells us that necessarily a bank is going to perform two essential functions: acceptance of deposits from the public and lending or investment of such deposits. So from the public, deposits are accepted, deposits are created for the public. So this is one important section. Another important section is section 22, which talks about the license. So it is necessary to have a license from Reserve Bank of India for commencing or carrying on the business of banking. So every banking company has to have a license from RBI. Apart from that, only those banking companies that have the license, they can use bank as part of its name. This is given under section 7 of the Act. Only those companies who have the license can use the word bank. No other company, no company other than the banking company, it can use the word bank, banker, or banking as part of its name. So these are the two important sections. So when we are talking about the deposits that are repayable on demand or deposits that are withdrawable on check, then acceptance of deposits apart from bank, the non-banking entities can also do, but these will not be the same. We already know why. We will see this in the NBFC part as well. Then we have said licensing of bank. Apart from these two sections, here I have given a list of other important sections. So 5B talks about the banking company definition. Section 22 talks about the license for banking. Then we have section 6(1) which tells us what are the permitted business. Now banks, traditionally the main business are deposit taking and loan or investing. Apart from that, they can also carry out many allied activities or unrelated activities like the bills of exchange, accepting or lending or advancing money with or without security, right? Managing, selling, portfolio management, various other activities are permitted. However, another section, that is the section 8, it tells us the prohibited business. This is important. This section 8 tells us the prohibited business. Banks cannot engage in any form of trade of goods. Goods means the movable property, anything, right? They cannot engage in the buying and selling. They cannot undertake the trading risk directly or indirectly. So these are prohibited. All right, these are the prohibited. This does not include the securitization part, but the buying and selling, the trading of the goods. This is prohibited. So prohibited activities are given under which section? The section 8. Then section 21 talks about the loans and advances, which types of loans can be given, which types of advances can be created. This is given under section 21. Then section 35A says power is given to RBI to give directions. So RBI can give directions to banks in terms of the business that they conduct, regulations or supervision, in terms of inspection. RBI can give directions as to how or how much loan has to be provided, the priority sector norms. This is given under section 35A, right? So next, we have section 26, which talks about the return of unclaimed deposits. Section 29 talks about the balance sheet, and section 43 talks about the CRR, the cash reserve ratio, which has to be maintained with the central bank. So these are some of the important sections. You need not go into the detail of these sections, only remember these and only these sections. Apart from these, there are many sections, there are many parts, chapters in the Banking Regulation Act, but we need to focus this for our tomorrow's examination. This, this list is the only exclusive list from which the sections can be asked. Alright, so remember these, at least these. I know, I have faith in you. You have already studied about the other sections also, but in today's revision, make sure that you remember these. All right, this was the Banking Regulation Act. Next, when we talk about the Reserve Bank of India Act, Reserve Bank performs various functions. First, foremost is the bank note issue. It is the wholesale authority that has, or wholesale institution that has the authority to issue bank notes, legal tender. Then it acts as a banker to the government, banker to the bank, lender of last resort. Also, it acts as other functions as well, right? We have some qualitative functions and quantitative functions under the monetary control policy of RBI. So Reserve Bank acts as the central bank of India. This act was enacted to constitute Reserve Bank of India and came into force from 6th March 1934. So we will remember the year. It was legislated with the primary aim to regulate the issue of banknotes and the keeping of reserves with a view to securing monetary stability. Apart from CRR, also the SLR, the statutory liquidity ratio. How does it maintain the monetary stability? If there is inflation in the country, RBI will decide to increase the CRR, so the loan giving power of the banks will reduce. Or if there is a deflationary situation, opposite will be done. Again, no need to go into detail, right? You just need to understand, okay, there is the legal reserve ratio which are maintained by RBI, which are told by RBI and kept by the banks. Now the important section, Section 3 authorizes RBI to take over the management of the currency from the central government and carry on the business of banking. Section 7, the central government may from time to time give directions to RBI. Okay, now central government also has power. Why? Because central government has to implement its fiscal policy. Fiscal policy. If you would have seen in the recent articles in newspapers, with the appointment of the new RBI governor, various government institutes or various government ministries, they have been telling that there's a situation of credit crunch in the economy. So how can it be resolved? So this is the directions that are given by government, but that is not a regular thing. It happens only in particular situations or special situations. All right. And also, RBI was this act, this power of central government to give directions has been utilized by the government only once. First and the only time when in October 2018. Okay, so we will write this down. Only in October 2018, government had given directions to RBI regarding what? Regarding the NBFCs, right? And the SMEs and the weaker capital requirement and so on. But it has been done only once. So section 7. Then section 17 functions mentions the functions of RBI to act as the banker's bank, lender of last resort, to act as the monetary authority. Then section 18, emergency provision. Section 21, the management of the public debt with the issue of loans to the central government. Section 22 talks about the wholesale right to issue bank notes in the country. And section 24, the denominations of the notes that can be in circulation. So these are the important sections from the RBI Act of 1934. I hope you all are understanding that these are the important facts that you need to cover, that you need to revise for tomorrow's exam. We are just discussing the important facts of all the acts. Right. Then we have the Department of Non-Banking Supervision of RBI, the DNBS. It is entrusted with the responsibility of regulation and supervision of the NBFC. So the regulation and supervision of NBFCs is now under the DNBS of RBI. Provisions contained under Chapter 3 and Chapter 5 of RBI Act. So Chapter 3 we will write down, and Chapter 5 talks about the regulation and supervision of NBFCs, that is to be done by the Department of Non-Banking Supervision of RBI, right? Then we have the Banking Ombudsman, the Integrated Banking Ombudsman. It is an authority originated, established under the Banking Ombudsman Scheme of 1995. We will study about the Banking Ombudsman Scheme in the further slides. This is given under Section 35A of the Banking Regulation Act. Very important. Not RBI Act, but Banking Regulation Act. Section 35A. Then cash reserve is to be maintained under section 42 subclause 1. It has been given the average daily balance being such percent of the total demand and time liabilities. We already know what CRR is, the cash reserve ratio. Then we also need to maintain the SLR, the statutory liquidity ratio, a certain percentage of the net demand and time liabilities. All right, so these are all the important sections. So question, from where question can be asked? From the Department of Banking Supervision. It is under RBI. Which chapter? Chapter 3 and chapter 5 for the regulation of NBFC, for the regulation of the non-banking financial companies. So we will remember this as important. All right. So here a structure of the banks are given in India. So we have the scheduled banks and the non-scheduled banks. Scheduled banks, we have the commercial banks and the cooperative banks. Commercial banks, public sector, private sector, foreign banks and RRBs. Cooperative banks, urban and state cooperative. The public sector banks includes the SBI and associate banks, other nationalized banks and other public banks. Private sector banks, you need to tell me the year from which we categorize the private sector banks. Before this year, these were characterized as old, and now after this year, they are characterized as the new private sector banks. Tell me the year very quickly in the comment section. Now we will discuss these banks in detail. So we have the State Bank of India, which was established under Section 3 of the State Bank of India Act 1955. Very important. For taking over the undertaking of the Imperial Bank and to carry on the business of banking and other business accordance with the Act. State Bank of India was established basically to include the public sector banks in the area of financial inclusion, to give more impetus towards rural banking, financial inclusion, financial education. The State Bank of India was established when 1955, right? Then we have the regional rural banks. Again, these are regionally based, rural oriented and engaged in commercial banking. They were first set up in 1975 under the RRB Ordinance of 1975. Later on, this ordinance was replaced by the Regional Rural Banks of 1976. So, if a question comes, under which of the following were the regional rural banks established? So, originally it was under an ordinance. Later on, it was replaced by the Act, the Regional Rural Banks Act of 1976. Okay. Then if we talk about the nationalized banks or other public sector banks, they came into being consequent to the enactment of the Banking Companies Acquisition and Transfer of Undertakings Act 1970 and the Banking Companies Acquisition and Transfer of Undertaking Acts 1980. This is the Bank Nationalization Act. So two acts are there under the Bank Nationalization Act. We have the Banking Companies Act of 1970, and then wherein the nationalization took place in 1969. Then we have the Banking Companies Acquisition and Transfer of Undertaking Act 1980. Alright, so if we are asked what are the bank nationalization acts, we know in two phases that nationalization were done of the banks. 1970, 1980. We already remember, we already know about these acts. These are the most basic things, right? So nationalized banks, these are apart, the public sector banks apart from SBI. Clear till now? All right. Next, we have the cooperative banks. Under which act the cooperative banks are licensed or established? These are registered under either the state laws governing cooperative or under the Multi-State Cooperative Society Act. So the Cooperative Societies Act. If this cooperative bank is operating in only one state, then under the state cooperative, the state laws, or if in more than one state, then the Multi-State Cooperative Societies Act is going to govern it, or this act is going to register the cooperative banks. Every cooperative society requires a license from the Reserve Bank, again under Section 22 of the Banking Regulation Act, to carry on the banking business in India. However, very important, the primary credit societies are exempt from the requirement. The cooperative banks, they require license under the Banking Regulation Act from RBI, but the primary credit societies do not require it. They are exempt from this requirement. Now, I had asked you about the private sector banks. So the private sector banks are those where the majority stake in all the cases is held by private entities and individuals. These are incorporated mostly under the Companies Act of 1956 or the New Companies Act of 2013. And other acts, other statutes also govern it, like the Banking Regulation Act, RBI Act, and so on. So the private sector banks. Okay. Next are the differentiated banks. Differentiated banks are established for certain purpose. For certain purpose. So the committee which was headed by Shri Nachiket More, very important. If there is a committee that has recommended the setting up of an institution or they have given recommendations, we need to remember the name of the committee. So the Nachiket More committee, they gave the recommendation to set up comprehensive financial services for small business and low income households, basically to look up into the issues of financial inclusion. So they came up with two broad designs for the banking system: the horizontally differentiated banking system and the vertically differentiated banking system. Right? Okay. So the Nachiket More committee, it recommended setting up of the differentiated banks, the horizontally differentiated banks and the vertically differentiated banks. The main purpose of these banks are financial inclusion. Financial inclusion. Another category of banks are the local area banks. These were started in the year 1996. A decision was taken to allow the establishment of local area banks in the private sector. And it was expected that the minimum startup capital of a local area bank would be rupees 5 crores. All right, with the promoters bringing in entire. So the local area banks are started by the promoters with a minimum startup capital of rupees 5 crore. This is the information that we need to remember. Another thing in the year 1996, right? Now the most important thing from where the questions can be asked are the NBFCs. The NBFCs, right? I hope you all are understanding only the important information that is going to be asked, or that is what we are expecting the institution will ask us in tomorrow's examination. That is all that we are going to discuss today. So yes, local area banks for the development of rural areas. Then we have NBFCs. We have already seen that the Department of the Non-Banking Supervision of RBI, they take up the responsibility, regulation and supervision of NBFCs under the Chapter 3 and Chapter 5 of the RBI Act. We have already seen this. Now if we talk about the NBFCs, what is the framework or how NBFCs work? So the NBFCs have been divided into four layers. It is based on their size, their activity, and perceived riskiness. So we have four layers: the base layer, then we have the middle layer, upper layer, top layer. So when we talk about the base layer, it would comprise of the non-deposit taking NBFC. So the NBFC ND, non-deposit taking NBFCs. And here we are talking about the size. So the size would be rupees 1000 crore, right? And the NBFCs that are undertaking the following activities. So the base layer has two types of NBFCs. First, those that are non-deposit taking. Second category, the NBFC peer-to-peer lending platform, the NBFC account aggregator, the non-operative financial holding company, and the NBFCs not availing public funds and not having any customer interface. Again, don't go into detailed explanation. Don't try to remember each and every detail. Just remember these headings. that these are the two types, or these are the two categories of NBFCs that are included in the base layer. This is the lowermost level, the base layer. So they have the asset size of below rupees 1000 crore, and these are the activities that they undertake. Okay. Next layer is the middle layer. Middle layer would consist of all the deposit taking NBFC. So the NBFCDs, irrespective of the asset size. All the NBFCs that engage in the business or activity of taking deposits will be included in the middle layer. Next, all the non-deposit taking NBFCs that have the asset size 1000 crore and above. So the non-deposit NBFC that had the asset size below 1000 year were in the base layer, but those that have more than the 1000 crore limit asset size, they are included in the middle layer. Then other than that, the standalone primary dealers, the infrastructure debt fund, that is the non-banking financial companies IDF infrastructure debt fund. Then we have the core investment companies, the housing finance companies, HFCs, and the infrastructure finance companies. So here, if we try to remember, we'll say that as the name suggests, the IDF and NBFC engages or gives funds to the infrastructure related areas, the housing finance companies for the housing needs, core investment companies, standalone primary dealers. All right, so these are included in the middle layer. Then we have the third layer, which is the upper layer. Those NBFCs which are specifically identified by RBI as warranting enhanced regulatory requirement. Why? Because their risk taking is quite high, right? So their riskiness, risk behavior, they are involved in the risk taking activities. So the upper layer includes those NBFCs that require enhanced regulatory requirement. And then we have finally the top layer, which would remain empty. Question was asked that which of the following types of NBFCs are included in the top layer. So none. The RBI tries to keep the top layer empty. It may be populated if the RBI is of the opinion that there is a substantial increase in the potential systematic risk from specific NBFCs in the upper layer. So those NBFCs that take risk are included in the upper layer. If among those NBFCs even higher risk is involved, then they will be shifted to the top layer. Otherwise, what will be done? This layer will be kept empty, right? So these are the four layers. We have the base layer, the middle layer, the top layer which is kept empty, and the upper layer. It is kept empty. Yes, we'll remember this. All of these. Then here the different types of NBFCs are given: loan company, the asset finance company, housing finance company, MFC, which is included in the microfinance, then the infrastructure finance, core investment, and so on. So these are the different types of NBFCs, and obviously NBFCs are very important because they give credit to the MSMEs. They are acting as microfinance, monetization of gold, affordable housing. They aid in employment generation, attracting foreign grants, development of financial markets. We have already seen what all schemes are developed by NBFCs in other papers, not in this one because it was not required here, right? So this is right. Apart from that, the capital guidelines, what all capital is required to be maintained by NBFCs, that is there, but we need not revise it today. Next, yes, next act that we are going to discuss is the Prevention of Money Laundering Act, the PMLA Act of 2002. The basic definition or the basic information is given. It was enacted in the year 2002 in response to India's global commitment, including the Vienna Convention, to combat money laundering. As the name suggests, to combat money laundering. So it enables the authorities to confiscate the property earned from illegally gained proceeds, appoint the adjudicating authority and the appellate tribunal to deal with the matters connected with money laundering. The act adds the concept of reporting entity, which would require a banking company, financial institution, intermediary. They need to submit regular reports to the reporting entity regarding their working, regarding the due diligence that they take. Now, when we talk about the tribunal, appellate tribunal, what is the composition of the tribunal? It includes a chairperson and two other members. What is the qualification of the chairperson? Should have been a judge of the Supreme Court or qualified to be a judge of the High Court. Not below this. That is, they should have a qualification of either being judge of the Supreme Court or High Court, not below this. And for the two members, a member of the Indian Legal Service or Revenue Service, Economic Service, etc. The term for which these chairpersons and members are kept, this is for a term of 5 years or till the age of 65 years, whichever is earlier. Function, here's the appeals against the orders of the adjudicating authority, the authorities under the PMLA. We also have the headquarter, the Enforcement Directorate, which was established in 1956. Its headquarters is in New Delhi. It is a multidisciplinary organization which is mandated to enforce the PMLA. So, which organization has been established or which organization has the authority to enforce the PMLA? It is not the central government or the RBI, it is the Enforcement Directorate. Very important. I don't want to hear in tomorrow's, after we discuss the paper, that we could not remember the agency that has been incorporated. We know it is the Enforcement Directorate. All right, the Enforcement Directorate. Apart from this, we are talking about the reporting agency which has been established. So, the maintenance of records. The obligations of banking companies, financial institutions, and intermediaries are enumerated in the chapter 4 of this act, comprising of section 12 to 15. So, they need to maintain information. Every information that is maintained, furnished, or verified, save as otherwise provided under the law for the time being enforced, shall be kept confidential. They cannot make this information public. They cannot share this information with any third party. They can only submit it to the reporting agency, right? Then the records referred to in the clause A, subclause section 1 shall be maintained for a period of 5 years from the date of transaction between the client and the reporting agency. So this report or this record will be maintained for 5 years only. All right. So the PMLA has these particular criteria, or we can say these particular sections that are important. Then the records shall contain all the necessary information specified by the regulator to permit the reconstruction of individual transaction. What are the information related to? So the nature of the transaction, the amount of the transaction and the currency in which it was denominated, the date on which the transaction was conducted, and the parties to the transaction. So these information about the transaction has to be maintained by the particular banking or financial agency. All right. So they have to maintain a record of all the transactions, including the informations that are covered in this particular clause. This is to enhance the due diligence, increase the due diligence, which are given in section 12 of the Act. Then a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted. The person cannot say that I wasn't myself included or I wasn't myself conducting this transaction. Any other person was doing this on my behalf, so I'm not responsible. No. If the person is either directly or indirectly involved in the transaction, which comes under the concealment, possession, acquisition, use, projecting as untainted property, or claiming as untainted property, these are connected with the proceeds of crime. So let's say if a person, they took a transaction, they gained money illegally, but they did not themselves use the proceeds. They gave it to some other person that was related to A, let's say B, and the B is making transactions using this proceeds, or B is keeping the track of these proceeds, then also this person A will be responsible, right? So either directly or indirectly they are involved in the illegal attempt. So they will be held responsible and they will be punished according to the PMLA guidelines. Then if we talk about the punishment, what punishment which has to be given, we have seen the information that has to be contained in the record. Punishment is given under section 4, that whosoever commits the offense of money laundering, they shall be punishable with rigorous imprisonment, and this imprisonment shall not be less than 3 years. This you need to remember. The punishment should not be less than 3 years, which can also be extended to 7 years. Minimum 3 years extended to 7 years, and also fine will be imposed. Alright, it can be extended to 7 years or it can be extended further as per the grievances, as per the level of the misconduct. So, this is all the information that you need to remember about the PMLA. Next, we have the Negotiable Instruments Act of 1881. This act nowhere defines the negotiable instruments. It only terms negotiable instruments, what all can be included. The promissory note, bill of exchange, or the check payable. So we will also not revise what these are in detail. We will only see that a negotiable instrument will include the promissory note, bill of exchange, either to order or to the bearer. It can be either an order check or a bearer check, right? This is given under section 13 of the Act. So when we talk about the bill of exchange, it is an interested payment. Promissory note is a self-payment. Check again is an interested payment. Now this is important. What are the basic parties involved in each of these negotiable instruments? In the bill of exchange, we have three parties: the drawer, drawee, and the payee. In the promissory note, only two: the drawer and the payee. And in the check, there is the drawer, drawee, and the payee. So, question can be asked: how many parties are involved in a bill of exchange contract, or how many are involved in the promissory note? So, we need to know that bill of exchange and check has three and promissory note has two, right? This is there. Then another important thing about the Negotiable Instruments Act is about the material alteration. What all can be included, or what all can be considered as material alteration. So alteration in the date of the instrument, which might have the effect of hastening or delaying the time of payment. Now alteration is allowed. Let's say we alter some detail of the check, for example, but this has to be with the permission of the authority, the bank or the financial institution. And also these should never be hidden. The alteration should be apparent, nowhere hidden. All right. Second, the alteration in the name of the payee will be considered a material alteration. Alteration of the amount, which is the most common form of fraudulent alteration. The person can add some digits in the amount that is mentioned in the check. And the alteration of an order check to a bearer check. If we change the nature of the check, make it a order check or make it a bearer check. So this law basically talks about whenever the negotiable instrument, it has undergone changes, and it has undergone any alteration, how is it going to relate? Will the bank be responsible, or will the bank be provided certain protection, right? So yes, this is there. Then yes, what else? Protection is provided to the paying banker under the Act regarding, however, the payment has to be payment in due course as defined in the Act for the protection. So protection is provided to the bank under which section? Under section 85. So we need to remember this section. Protection is provided to the paying bank. Let's say if a person has signed a check in the name of another person. These are in two different banks. Their bank accounts are in two different banks. This check, due to the lack of funds in the person A's account, is rejected. then will the bank be liable or will this person A be liable? This is what we are talking about. So there's also protection available to the banker where the checks are fraudulently altered but are done so that the alterations are not visible, they are not discernible to the eye. So if the alterations were done by the person and these are not clearly visible, these are somewhat fraudulent, then also the banks will be provided protection. So these two conditions are there. Either the payment has to be a payment in due course. Second, if the alteration has been a material alteration but fraudulently done. Also, the collecting bank is also accorded protection under Section 131 of the Negotiable Instrument Act. Again, this is subject to certain conditions like the check should be crossed, collection on behalf of the customer only, there being no negligence on the part of the bank. So if these things are there, that the bank has duly crossed the check or that the collection is done only on behalf of the customer or there is no negligence on part of the bank, then also the paying banker will be provided protection. This is in the case of section 131. Otherwise, section 85 talks about the fraudulent activities wherein the bank will be provided protection. Go through this, go through all of these facts very quickly. So when I'm saying payment in due course, it means that the payment should be done with the apparent tenor, the time period. It should be done in good faith without any negligence. We know all of this, right? We already know this. Material alteration wherein substantially it alters the instrument and the liabilities to the parties, right? I think that is enough from this particular act. Yes. Next, we move on to the FEMA Act, the Foreign Exchange Management Act of 1999. This act was brought into force replacing the FERA Act, the Foreign Exchange Regulation Act, which was earlier. It was replaced and the Foreign Exchange Management Act was brought in 1999. So the object was to consolidate and amend the law relating to foreign exchange with the objective of facilitating external trade and payments and for promoting the orderly development and maintenance of foreign exchange market in India. This was why, because in the year 1991, with the economic reforms of LPG, the liberalization, privatization, and globalization, there was a greater need towards more liberal foreign exchange policy. So, outward looking foreign exchange or globalized economy, keeping these things in mind, the Foreign Exchange Regulation Act was somewhat very stringent. It had various restrictions, right? So it did not allow export, import, or globalization, or we can say the foreign direct investment or foreign portfolio investment was very restricted. So to change all of that, the FEMA was enacted. Now, RBI has the following powers under FEMA because we need to see this in terms of banking regulation. RBI has the power to appoint the authorized persons that are going to deal in foreign exchange. The person so appointed shall deal in foreign exchange only as per the rules and regulations that are formed under the Act and orders that are issued by RBI from time to time. Then, to inspect the authorized persons, RBI also has the power to conduct inspections to ensure that the said person so appointed complies with all the rules and the regulations that are formulated by RBI from time to time. So, RBI has these two powers under the FEMA Act. So, when we are talking about the authorized person, the authorized money changer or dealer, or the offshore banking unit, or any other person that is authorized under FEMA, then when we are talking about the capital account transaction, very important. The difference between capital account transaction, current account transaction, and repatriate to India. Capital account transaction means by which there may be a change, either increase or decrease in the assets or liabilities outside India of the persons resident in India, or the assets or liabilities in India of the persons resident outside India. So there is a concept that is known as the balance of payment. I'm telling this here so that you just remember. It is divided into the capital account and the current account. So when there is a change in the asset or liability, it any transaction that changes the asset liability situation, it is in the capital account, and any transaction which does not change in the asset or liability situation, then it is in the current account. Very simple. All right. So the capital account transaction which increases or decreases the assets or liability, that is in the capital account. Current account, other than the capital account, payments due with the respect to the foreign trade, other business services, short-term banking, credit facilities, payment due as interest on loans and income from individuals, remittances for living expenses. A very simple example I will give you. If my relative resides abroad in, let's say, USA, and they send me a gift on birthday. They send me a gift on my birthday. I'm not rendering any service in return. It is what? It is a unilateral transfer, a one-way transfer. So it neither increases or decreases the foreign exchange situation. So that is a current account transaction. So remittances for living expenses of parents, spouse and children, expenses in connection with foreign travel, education. So where no change is occurring, it will be the current account. So we will remember this as no change. And the capital account will be remembered as yes change. It is changing the asset or liability situation. Okay. Then we have the repatriate to India, which means bringing to India the realized foreign exchange. The realized foreign exchange. Selling of such foreign exchange to an authorized person in India in exchange for rupees. We are changing currency. We are changing currency. So if I'm changing US dollar for Indian rupee, this will be calculated. All right. So the selling of foreign exchange to an authorized person in India in exchange for rupees. The holding of realized amount in an account with an authorized person in India to the extent notified by RBI. It also includes the realized amount of the discharge or debt or liability denominated in foreign exchange. So wherever we are using the foreign currency, it will be included in the third category. All right. So very important, remember the difference, remember the definition of the capital account, current account and the repatriate. Go through this one. Let me know if it is clear or do you need any more explanation. Security is defined as the shares, stocks, bonds. Then person resident in India who are residing in India, they are taking employment in India. Person resident outside of India, the person who is taking up employment outside India for certain days, right? Then for the regulation and the management of foreign exchange, to deal in the transfer of any foreign currency, to make payment for any credit outside, for the person living outside India, all of this will be governed under the FEMA Act. Then RBI has the power to appoint the authorized persons and to conduct the investigations or let's say inspections. Then in terms of contravention or penalties, if we are talking about, so if any person they acquire the foreign exchange illegally, or they are acquiring any foreign security or immovable property outside of India, and this is outside or more than what is stipulated by RBI, this will be included in a contravention and it will attract penalty. Then any foreign security or immovable property exceeding the threshold, then all of this will be included. And the adjudicating authority will indulge, they will say such and such penalty will be imposed on the person. All right. So for this, the Directorate of Enforcement has been established by the central government. They have the power of search and seizure of the property. And also central government can empower other officers. They can authorize any customs officer or central excise officer, any police officer, so that they can conduct the investigation, they can search about the information. So that is there. So the Directorate of Enforcement, we will write this down here, the Directorate of Enforcement as established by the central government as the appellate authority. All right. Next, we have the Payment and Settlement Systems Act of 2000, the PSS Act of 2007, which is related to those institutions that are providing financial services like of the payments, the supervision of payments. So RBI is the authority designated under the act for the supervision of the payments, etc. So the appellate authority, the main authority for the regulation and supervision is the RBI. All right. So the Reserve Bank shall be designated authority for the regulation and supervision of the payment systems. They shall exercise the powers, perform the functions, and discharge their duties as conferred on it under the Act through a board that is to be known as the Payments Regulatory Board. So RBI has under it the Payments Regulatory Board that is going to perform all the functions as given in the Act related to the supervision regulation of the payment system. So this is very important. The board shall consist of the following members. The governor of RBI will be the ex officio chairperson, right? Then the deputy governor of RBI will be in charge of the payment and settlement systems. They will be the ex officio member. One officer of the Reserve Bank to be nominated by the Central Board of the Reserve Bank member, which will again be the ex officio, and three persons which are to be nominated by the central government. So the ex officio chairperson and ex officio members are from the RBI itself, right? The RBI governor will be the chairperson, the deputy governor will be in charge of the payment and settlement system. The one more officer will be nominated as the ex officio member. Apart from this, three persons will be nominated by the central government who will act as the members. All right. Then, if we talk about the authorization, it is given in section 4 of the Act. According to section 4, no person other than RBI can operate any payment system. All the payment systems that are operating in India, they are under the authorization of RBI. They cannot operate without the authorization of RBI. So no person other than the Reserve Bank shall commence or operate a payment system except under and in accordance with the authorization issued by Reserve Bank, right? Also, there is the term of rule for changes. No payment system can make any change in their functioning without telling the public or without informing in a public notice. So section 11 tells us that no system provider shall cause any change in the system which would affect the structure of the operation of the payment system without informing. All right, so they cannot make a significant change in their payment system. So this is the authorization that is given, and RBI has this authorization. The RBI can also refuse authorization or they can revoke the authorization of a payment system if they find that they are not conforming to the provisions of the Act and the regulations, right? So for this, the activities that are undertaken by them, the technical standards that are designed for this, the terms and conditions of the operation. All of these things RBI will take into consideration, and if they find that they are adhering to the norms, then they will give the authorization. Otherwise, they can refuse or they can also revoke the authorization. Right? So this authorization will tell what? It will state the date on which it takes place, the conditions to which the authorization shall be in force. It will also tell about the information, all the information that the payment system will have to furnish to the RBI. All of these things will be there, right? So this payment system, if they're making any changes, they have to take prior approval from the RBI, and they have to give at least a notice of not less than 30 days. A notice of not less than 30 days has to be provided to the system users, the system participants, after the approval of RBI. So this is the rule of change under section 11, the rule of changes, very important. So they have to take prior approval of RBI, and then they have to give 30 days notice to the participants before they implement the changes or after the authorization. Then section 23 deals with the settlement and netting. The settlement and netting under the payment system. The payment obligations and settlement instructions among the system participants shall be determined in accordance with the gross or netting procedure. We know that the payment system, they make payments either on a net basis, like individual payments are completed, or on the gross basis. We know about the RTGS, IMPS, NEPS, right? So either net or gross. Relating to that, all the provisions are given in section 23. So approved by the RBI while issuing authorization to a payment under section 7. So such gross or netting procedure will be approved. So the payment system will have to state whether they are going to undertake the payments on a net basis or on the gross basis, whether their settlement will be done on netting or gross procedure. All right, this is also there. And we have already said what all things that they need to follow. Then the information or inspection. So Reserve Bank will have the right to access any information related to the operation or functioning of the payment system, and they will have to provide access to such information to the RBI, right? RBI, any officer of RBI that is duly authorized by it, they can ask for this information. They also have the power to issue directions, like related to the cease and desist from engaging in a particular activity, or if there is any proved misconduct or omission, or they're not following the provision relating to that, RBI can issue directions. All right, RBI can make regulations as well, the powers and functions of the board to form the manner in which the authorization will be carrying on. All of these things are there. Basic things, obviously, RBI will have the power to inspect and supervise. Okay. Next, we are going to discuss the laws related to securities, wherein we will discuss the modes of charge, the different charge, mortgage, and so on. So, what is a charge? We know already a charge, it can be the interest or right which a borrower or guarantor creates on their asset, right? In the favor of the lender or creditor. So, the relationship between two persons, wherein one person is the creditor and other person will be the borrower, right? So when they are creating a charge, they are going to borrow funds, keeping in terms the security. So they're going to create a charge. A very basic explanation, a very basic definition. And what will happen if the creditor fails to repay or they fails to pay back the debt? What will happen then? So all of these things are created in the charge. We have two types of charge. We have the fixed charge and the floating charge. Then the method of creating the charge will depend upon the security and the nature that is the nature of charge that is being created. So we are going to discuss about these different securities, the different processes. First, we have the mortgage. There are six types of mortgage. We will discuss about these six types in detail in the next chapters. We have the simple mortgage, mortgage by conditional sale, the usufructuary mortgage, English mortgage, mortgage by deposits of the title deeds, and the mortgage that does not follow the conditions or the nature of any of the above. We have the anomalous mortgage, right? So, mortgage, the transfer of interest in the specific immovable property. Okay, immovable property. Here I am hoping that you already, from reading the term, you can connect it that what is a mortgage? It is the transfer of interest in the specific immovable property for securing the payment of money, right? So there should be a transfer of interest in the property by the mortgager. Only the transfer of interest, right? Then simple mortgage without delivering the possession, or conditional mortgage in which condition it will become absolute. The usufructuary mortgage, the implications that binds himself to deliver the possession, what are the particular reasons for the transaction. English mortgage, wherein again the mortgager binds himself to repay the mortgage money on certain date, on certain time. Okay, so these are the things we will see in detail. Now, the Indian Contracts Act of 1872 lays down the rules for appropriation, which is another form, appropriation, which is applicable to a creditor who receives the payment from a debtor, and is equally applicable where the bank is a creditor. So now we are talking about the appropriation. Right. So the Indian Contracts Act includes the rules for the appropriation. Wherever a debtor that is owning several distinct debts to one person, they make a payment either with express intimation or under circumstances that we term as implied conditions, what will happen to it? So that is appropriation. My voice is clear, right? Okay. Right. So appropriation is the application of a particular payment received from a debtor for the purpose of repayment of a particular debt. Basically applying the funds that are received from a debtor for paying a specific debt. We are using the funds. If let's say I owe several debts, I have to pay to several creditors, then I will receive funds from one particular creditor and I will use it to pay another person. That is what appropriation basically means. So if A owes B among various debts and they fail to pay on the first debt, what will happen? The payment will be applied to a discharge. So we are taking into account the promissory note for the appropriation. Don't We don't need to go into detail again. Basically, the appropriation is included in the Indian Contracts Act. Mortgage is included in the Transfer of Property Act. So the Transfer of Property Act of 1882 contemplates the mortgage. The Indian Contracts Act 1872 includes the appropriation. Then we have assignment. Assignment means the process by which a person called the assigner prefers to transfer the rights or benefits to another person, which is called the assignee. However, there can be no transfer of a duty, burden, or any detriment without the express agreement of the assignee under the assignment. So, the assigner and the assignee. This person, assigner, is saying that I will transfer my due or my burden to this person assignee, but it has to be done on an express agreement. On an express agreement. It cannot be on the implied understanding that no, this person is my friend, so I will assign my due on it. No. So therefore, this is a consent. It is based on a consent. Then next we have a pledge. When we talk about a pledge, so there are three requirements that are to be satisfied. There must be a bailment of goods. The bailment must be on behalf of the debtor, and the bailment must be for the purpose of providing security for the payment of a debt or performance. I've included all of these points just so that you can very quickly revise the meaning of a pledge, the meaning of appropriation, what is bailment. So pledge means the bailment of goods for the purpose of providing security for the payment of debt or for the performance of a promise. So wherever we are talking about the agreement, wherever we are talking about the agreement, it involves two things. We will also discuss this when we are talking about the contract, right? So agreement will be with the consent of the two-person to pay off a debt, let's say. So pledge will mean the bailment of good. Where we are talking about the pledge, we will use the term pawner and pawnee. I have stated this earlier also. The person who is making or starting the contract or starting the agreement, we will use the word ending with or, and the other person with double E. So whether we are talking about the bailor bailee relationship, the pawner pawnee relationship, mortgager mortgagee relationship, similarly we are going to use it for all the terms, right? So the person whose goods are bailed is known as the pawner, and the person who takes the goods as security is known as the pawnee. So bailment, where the actual goods transaction it takes place, we are creating a pledge on it so that security, the goods can be used as security. So let's say by handing over the keys for the go down in which the goods are kept, or by let's say handing over the documents of title to the goods, or even if the goods are in the possession of the owner, they can give an acknowledgement, a written acknowledgement. So pledge can be created only in the case of existing goods which have to be in the possession of the owner. All right, there is no pledge on future goods, existing goods in the possession, in the physical possession. And this possession of goods is the most important characteristic of the pledge. Next, we have the mortgage of movable property, which is known as hypothecation. When we talk about mortgage, we are referring to the immovable property. But when we are talking about the mortgage of movable property, then it is known as hypothecation. It is a transaction whereby money is borrowed by the debtor, who is the owner of the goods, on the security of the movable property without transferring either the property or the possession to the creditor. So we are just hypothecating. When we talk about a hypothesis, so we are making an assumption, right? We are only making an assumption. Nothing is happening in reality. We are assuming, okay, it might rain tomorrow. We have no proof of that until and unless it occurs. So we are creating a hypothecation without transferring either the property or the possession to the creditor. What we are doing, we are taking a transaction. So security is created on the movable property. Then when we talk about set off, it is the right of a debtor to take into account a debt owing to him create by a creditor when claiming a debt from him to the creditor. Again, I will repeat, set off is the right of a debtor to take into account a debt owing to him by the creditor when claiming a debt due from him to the creditor. So we are setting off. We can say we can cancel off. We are setting off, we are cancelling off one debt to another. So in case of a banker, the right of set off enables him to adjust a debit balance in a customer's account with any balance that is outstanding to his credit in the books of the bank. So if a person A has taken loan. Also, this person A has a deposit. So in simple terms, what the bank can do, they can debit the balance. They can adjust the debit balance from this particular account. So in terms of banking, this is the meaning of set off. In general terms, it is the right of a debtor. They are exchanging the debt, right? That is set off. Then if we talk about charge, so charge means an interest or a lien that is created on the property or assets of a company or any of its undertakings. Both has security and includes a mortgage. So a charge can be an interest or a lien and it is created on the property. These are the characteristics that you need to remember. A charge can be either an interest or a lien and should be created on the property or the assets of a corporation or any of its undertakings or both as security and includes a mortgage. This is the complete definition of the charge. So the charge requiring registration in terms of section 77(1) of the Companies Act of 2013. So it shall be the duty of every company creating a charge within or outside India on its property to register the particulars of the charge signed by the company and the charge holder together with the instruments. So whenever a company is creating charge on its security or they're creating security on the property, they need to get it registered, right? They have to register this charge, and this registration has to be done with the registrar of companies. Thus all the types of charges are required to be registered with the registrar of companies. This has been stated. All right, so we have seen what is a charge, then the charges that are requiring registration. So any company that are creating charge, doesn't matter the charge is created in India domestically or outside of India, within or outside of India, on its property or any of the assets of undertakings, they can be tangible or intangible, they have to be registered with the registrar of companies, right? So charge for the purpose of securing any issue of debentures or let's say on any uncalled share capital, immovable property, any book debts, anything. So what we can conclude, what we can summarize here, that irrespective of whether the charge is within or outside India, or whether it's on the company's own property or assets or any of its undertakings, or whether the charge is tangible or whether it is fixed or floating, doesn't matter if it is situated in or outside India, they have to get it registered. And this registration has to be with the registrar of the companies. All right, so registrar of the companies. Then we also have the charges that do not require registration. Which type of charge do not require registration with the ROR? Any corporate guarantee, charge that is arising due to the operation of some specific law, or hundi, which is a negotiable instrument. So these are the three areas, these are the three types where the charge will not be required. Otherwise the charge will be required. The companies, they have to register the charge with the ROR. All right. Then charge will have to be registered within how many days? Within 30 days of creation. This can be asked in the fill in the blanks. The same statement can be asked, charge will have to be registered within dash days of the creation of the charge and some additional time is permitted. So 30 days. Within 30 days of creation, they have to register, get the charge registered. If, however, the charge created is not registered, then the same is invalid against the liquidator appointed under the Companies Act or the IBC Act and other creditors as well, on winding up of the company or otherwise. So if you do not get the charge registered, then what will happen? It will be considered invalid. All right. So we have the different types of charges. We have the fixed charge which is created, and we also have the floating charge. Fixed charge, which is also known as specific charge over a specific property or more than one property, properties of the company, particular or specific, like for when it is given for a loan. And floating charge, which is general, it is not specific. So charge that floats over the present and the future property, or it does not restrict the company from assigning the property, right? We also have the cases when the floating charge becomes a fixed or crystallized charge, like when the debtor company, they ceases to carry on business, the business is no longer being continued, or the business goes into liquidation. Then what will happen? The floating charge becomes a fixed charge. The floating charge will change into a fixed charge in case when the company ceases to carry on business or goes into liquidation, or the debenture holder or the creditor, they are what they're doing, they're arranging for a receiver, right? So in this case, the company is deciding to dispose the assets that are charged, so it will turn into a floating charge, right? So fixed is on specific property, floating is on general. Although this is a very generic term, I don't think the institution will ask, but still you should know what is a fixed charge and a floating charge. All right. So okay, we have already completed two modules, Module A and Module B. The small modules are done with. We have completed the revision. Now we move on to the bigger modules, the more important modules, or those that have greater weightage, are Module C and Module D. First, we have the Reserve Bank Integrated Ombudsman Scheme. So here, this act says we are talking about the integrated ombudsman scheme. Integrated will mean certain things are coming together. We are seeing the merger. So, merger of three earlier schemes, the Banking Ombudsman Scheme of 2006, the Ombudsman Scheme for NBFCs, and the Ombudsman Scheme for Digital Transactions. All of these three acts, these schemes have been integrated into the Reserve Bank Integrated Ombudsman Scheme of 2021. The four most important information that we need to remember separately, we already know. The Ombudsman Scheme is for grievance redressal, not a new information. So earlier there were three different schemes working for the grievance redressal for NBFCs, for the digital transactions, and for the banking. Now they have been integrated under the RBI Integrated Ombudsman Scheme. So the Ombudsman Scheme was operative from 1st January 2006. Later on, it was amended, and from November 12th, 2021, in the exercise of powers conferred under Clause 35A of the Banking Regulation Act, the Clause 45L of the Reserve Bank of India Act, and the Clause 18 of the Payment and Settlement Systems Act, in supersession of any of its earlier notifications. What has been done? The three existing ombudsman schemes have been integrated into one. This is what we just discussed. All right. So this scheme is going to cover the all the commercial banks, the regional rural banks, the cooperative banks, scheduled and non-scheduled urban cooperative banks, the NBFCs, excluding the housing finance companies, right? Then it will also cover, in terms of RBI, any other credit information company, all the system participants. All of these will be included in the integrated ombudsman scheme now. So if we talk about the appellate authority, it will mean the executive director in charge of the Department of Reserve Bank. So the executive director in charge. Executive director in charge will act as the appellate authority. Then the appellate authority secretariat will be the department in the Reserve Bank which is administering the scheme. Award will mean the award that is passed by the ombudsman if the client faces grievances regarding any performance of the activity or duty of the bank, or they have some mental agony. So regarding that, what award will be given, how they will be corrected, that is the award which is given by the ombudsman, right? So the person, if we have any complaint, we reach out to the bank, we reach out to the higher authority. If then also within 30 days the bank is not providing a solution, what we can do, we can reach out to the ombudsman. We have studied about the ombudsman scheme many times. So, clause 10 lists the circumstances under which a complaint would become non maintainable. So, once the ombudsman they receive the information, if we talk about the appointment and tenure of the ombudsman, so RBI may appoint one or more of its own officers as the ombudsman and the deputy ombudsman. Location, earlier there were locations created in such places as specified by the Reserve Bank. Then we today we also have the centralized receipt and processing center. The right, the centralized receipt and processing center which receives all the information. All right, then we already know what is the procedure for the redressal of the grievance. Any customer that are aggrieved by the act or omission of the regulated entity, they can file a complaint related to a various cases. Here we have mentioned all the circumstances where the complaint is not maintainable. If the complaint is a commercial, is related to a commercial judgment or commercial decision of a regulated entity, if it is regarding a dispute between a vendor and a regulated entity, grievances that are not addressed to the ombudsman directly, the general grievances against management or executors. So question can be formed from this, like which of the following complaints will become non-maintainable under the ombudsman scheme. So you should know complaints of commercial natures, disputes in which action is initiated by the regulated entity in compliance with the order, that any action that is taken by the regulated entity is according to the legal actions. Services that are not within the regulatory purview of the Reserve Bank, disputes between the regulated entities, or disputes involving the employee employer relationship. So all of these will be outside of the coverage or outside of the purview of the ombudsman scheme. The CRPC or the ombudsman, they will not accept these particular complaints, and they will also tell it, or they will convey to the person, the complainant, that why the complaint is non-maintainable. All right, and we have already seen the appellate authority means the executive director in charge of the department of the Reserve Bank administering the scheme, right? Then regarding the procedure, we know the filing of the complaint will be under clause 11. This will be received by the CRPC. If however the complaint is submitted in the physical form, it should be duly signed by the complainant. And if the complaint is submitted in electronic form, as the terms and conditions mentioned by the Reserve Bank, the CRPC will receive it. Doesn't matter whether it is electronic or physical, they have to take recognition. Then resolution, the ombudsman, they will try to promote settlement of a complaint. Then if the regulated entity, they are receiving the complaint, then within 15 days before the ombudsman for resolution, they have to provide all the copies. So that is there. And the complaint would be deemed to have been settled or resolved when it has been settled by the regulated entity, or the complainant has agreed in writing or otherwise that they are satisfied with the action that has been taken by the regulated entity, or the complainant has withdrawn the complaint voluntarily. All right, so in these cases it will be done. Then regarding the passing of the award and the also the right to prefer to the appeal, So we told that award is the decision that is taken under the Ombudsman scheme. So when the Ombudsman takes a decision, they will provide the regulated entity with an order to perform their duty or the obligation. Along with that, they will also award a compensation. Right, this compensation will not be more than rupees 1 lakh. Compensation to the complainant in terms of the expenses that are incurred, time, harassment, and mental anguish that was suffered by the complainant. So, to compensate that, this compensation will also be awarded, and the copy of award shall be sent to the complainant as well as the regulated entity. Right? And both the regulated entity as well as the complainant, they will have the right to prefer an appeal. This is given under the clause 17. So, appeal is given in the clause 17. Next. Now, when we talk about the MSMED Act, the Micro, Small and Medium Enterprises Development Act of 2006, the most important topic or theme from this chapter is the definition. The definition of the MSME classification. So we will make this comparison. Earlier criteria was investment in plant and machinery or equipment. That is, we divided the enterprises into the manufacturing enterprises and the services enterprises. Later on, with the new definition, we have combined it. Now, manufacturing and services enterprises, they are taken under one classification. Also, the classification or the criteria has changed. Earlier, the criteria was investment in plant and machinery. Now, we are using a composite criteria, investment and the annual turnover. So, if the investment of a manufacturing enterprise is less than 1 crore and the turnover is less than 5 crore, then it will be termed as a micro industry or micro enterprise. Doesn't matter if it is involved in manufacturing or services. If it is involved with an investment less than 10 crore and turnover less than 50 crore, it will be termed as a small enterprise. And if the investment is less than 20 crore and turnover is less than 100 crore, then it will be termed as a medium enterprise. So very important. If question comes from this chapter, it will be related to the definition of MSME. Earlier definition has been changed and the new composite criteria and classification is used for the revised MSME classification. So now we talk about the MSMED Act. It was enacted to facilitate the promotion and development and enhancing of the micro, small and medium enterprises and the rural development as well. Right? So it became operational from October 2nd, 2006. If we talk about the coverage, so we have already seen it covers the manufacturing as well as the services. Now, certain definitions under this Act. The advisory committee means the committee constituted by the central government under the subsection 2 of the section 7. So section 7 subsection 2 talks about the advisory committee which is constituted by the central government under the Act. Right? Then we have the appointed day. It means the day following immediately after the expiry of the period of 15 days from the day of acceptance or the day of deemed acceptance of any goods and services by a buyer from the supplier. So, seller and buyer, the exchange of goods and money, the appointed day will be the day immediately after the expiry of 15 days. So when the buyer accepts the goods from the seller 15 days immediately after the period, then it will be the day of acceptance. So the day of acceptance is the day of actual delivery of goods or the rendering of services. So this was the appointed day. All right. The day of acceptance is the day of actual delivery of goods or rendering of the services. Or where there was an objection made in writing by the buyer regarding the acceptance of the goods or services within 15 days from the day of delivery. Then we have the day of deemed acceptance. where no objection is made in writing by the buyer regarding the acceptance. So it is the day of deemed acceptance. We are accepting that on this day the delivery of goods or the rendering of services will be made. Then another important topic of this particular act is the National Board for Micro, Small and Medium Enterprises. So it is the advisory committee that we just talked about. The National Board for the MSME, with effect from when central government by notification they can appoint a board that will be known as the NBMSME. All right. So it will consist of 47 members, out of which 18 are ex officio members. The term of office of the board shall continue so long as he holds the office by the virtue of which he is a member. Then the board provides representation to all the sections or segments connected to the MSMEs, including the associations of micro, small, and medium manufacturing and services enterprises, women enterprises, central ministries, states, trade unions, etc. So, this particular board will provide representation to all of those associations, all of those enterprises that are involved in the MSME sector. So examining the factors affecting the promotion and development of MSME, then making recommendations into the matters that are related to the MSME. They will also advise the central government on how they can use the funds that are constituted under the section 12, right? Then also an advisory committee is constituted under section 7 of the MSME Act by notification under the chairmanship of the Secretary, Ministry of Micro and Small and Medium Enterprises. So the Ministry of Micro, Small and Medium Enterprises sets up the advisory committee for the MSMEs. This advisory committee usually comprises of 5 officers of the central government who are having experience in the matters relating to micro, small and medium enterprises. 3 are representatives of the state government and 1 representative each from the MSME association. So we need to remember the composition. The advisory committee will include 5 officers from the central government. Apart from that, 3 representatives of the state and 1 from the MSME associations. So 3 topics are important from this chapter, most important being the definition. Then we have the NBMSME and then we have the advisory committee that is created by the central government. All right. So if we talk about the penalties or we talk about the punishments, in terms of section 27, whoever intentionally contravenes or attempts to contravene or abets the contravention of any provision given in subsection 1 of section 8, they will be punishable. So when we are talking about the contraventions or when we are talking about any misconduct, so let's say any buyer who does not make a payment or there is a delayed payment. So there's a liability of the buyer to make payment which is under section 15. So wherever the supplier supplies any goods or renders the services, the buyer shall make the payment on the date or before the date that is agreed between them, and date from which the rate at which the interest is payable if the buyer fails to make a payment to the supplier under section 15. Then the buyer, they will have to, according to the agreement, they will have to pay a compound interest for the delayed payment. This is also given under the act. They will be liable to pay the compound interest with monthly rest to the supplier. All right. So herein it is given in the case of first conviction with fine which may extend to rupees 1000, and the case of second or subsequent conviction with fine which shall not be less than rupees 1000, but it may extend to rupees 10,000. So if a person involved for the first time, they are they are being convicted, so then the fine will be extended to rupees 1000 if it is the offense for first time. If however they continue to keep the delay, or they continue to make the misconduct, then in the second or subsequent convictions, what will happen, increasingly it shall not be less than 1000, and it may extend to rupees 10,000 for subsequent contraventions or convictions. So this is the penalty. Okay, that is all from this particular act. Next we have the SARFAESI Act, the Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act of 2002. Again, SARFAESI Act, we have also studied about this act in detail when we were preparing for the JAIIB exam. So the banks and the financial institutions, we know they lend money on security, but there are very many cases when NPAs are created, bad loans are created. So to recover those loans, the SARFAESI Act is working. So for the unduly long time that before the SARFAESI Act came into consideration and before it was enacted, the banks had to undertake the long legal framework for the recovery of dues. So this act was a major step as a financial sector reform for the securitization of financial assets, for the reconstruction, power to enforce such a security for the realization of money. So when we talk about this act, it act extends to the whole of India, including the state, now the Union Territory of Jammu and Kashmir. It is effective from 21st June 2002, and the act is applicable also to the housing finance companies whose names are notified by the central government. So this act is extended to whole of India. It is applicable to cases where the security interest for securing the repayment of the financial asset is more than rupees 1 lakh, and the amount is due 20% or more of the principal amount and the interest. So we have two conditions. First, if the amount or the repayment of the financial asset is more than 1 lakh, and at least 20% of the principal amount and the interest is due from the loan, then the bank or the financial institute, they can initiate the SARFAESI Act. They can initiate the securitization or reconstruction under the act. However, the act is not applicable. Very important. Where is the act not applicable? It is not applicable to any security interest that is created on agricultural land and certain properties that are not liable to attachment under some specified act. So it does not apply on agricultural land where the interest is created on the agricultural land. SARFAESI Act cannot be initiated. So any person that is aggrieved by the order. Okay, so under the SARFAESI Act, the debt recovery tribunals are created. We also have the debt recovery appellate tribunals. So if we are talking about the appellate tribunal, the debt recovery tribunal passes the order in SARFAESI Act if any person is aggrieved by the order that is passed by the DRT. Then they can file an appeal to the authority that is known as the DRAT, the Debts Recovery Appellate Tribunal, within 45 days from the date on which a copy of the order aggrieved has been passed or deemed to have passed. But there is one condition, that they need to deposit 50% of the claim amount. Let's say the DRT passed uh, an award, or they gave a decision, but the financial entity is not satisfied with it. What they can do, they can file an appeal within 45 days, but they need to make a 50% deposit of the award that was given by the DRT. That is why the DRTs have been constituted, and the tribunals are constituted by the central government for various states as per the provisions of the Recovery of Debts Due the Bank and the Financial Institutions Act, right? Then regarding the asset reconstruction is the acquisition by any ARC, the asset reconstruction company, or we can say for any right or interest of any bank or financial institution for the purpose of realization of such financial assistance. So what is asset reconstruction company? It means a company that is registered with the Reserve Bank under section 3. So this section is important. Under which section does the ARC get registered with the Reserve Bank? Under section 3. Why? For the purpose of carrying on the business of asset reconstruction or securitization or both. We know what is the meaning of securitization and what is the meaning of asset reconstruction. So securitization means acquisition of financial asset by the asset reconstruction company from the originator. And reconstruction will be the further steps that are taken for the realization of the money, for the realization of the value. So the asset reconstruction company can commence or carry business only after complying with two conditions. First, they need to obtain certification of registration from RBI, that is under section 3, and it has the owned funds at the time of registration not less than rupees 2 crores. So two conditions are given. Their net owned funds should be rupees 2 crore or any amount that is given by RBI, and they need to get themselves registered, and during this time of registration this should be their own capital. All right. Also, under the section 4 of the SARFAESI Act, the registration granted to the asset reconstruction company by RBI is cancelable. When can the registration be cancelled? Let's say the ARC stops functioning as an ARC. The functionings of reconstruction and security is no more performed by the company. Then the registration can be cancelled. Or if they cease to hold any investment from the qualified institutional buyer or the promoter, if they submit or offer for inspection in the books or account and they obtain prior approval from RBI, if they want to change the office, or they want to change the name, so the cancellation of certificate of registration is also possible, which is given in section 4 of the Act. Now, the asset reconstruction company can acquire the financial asset of any bank or financial institution by any of the following ways. So, there are certain ways through which the acquisition of rights of interest can be done, either by issuing a debenture or bond or any other security in the nature of debenture for the agreed consideration. So, what we'll take from here, what we'll remember, first way through which the financial asset can be acquired is the issuing of a debenture or bond. Second way is by entering into an agreement. Second way is entering into an agreement for the transfer of financial asset to such company. So any document that is executed by the bank terming the terms and conditions with the ARC, if the bank or financial institution is holding any right, title or interest to the secure payment of the unpaid portion, it will have to be mentioned in the document, and all of this should be expressly stated, right? Okay. Now, for taking possession with the help of the Chief Metropolitan Magistrate or the District Magistrate. So, under the SARFAESI Act, for the implementation of the security interest for the securitization or reconstruction, the authorities can do what? They can take possession or they can take help of the Chief Metropolitan Magistrate or the District Magistrate, or any authorized officer can be taken. So the authorities, the officers, they can take help from these persons. In such an event, the possession is taken by the authorities and handed over to the creditor. So these authorities, they will take the possession of the security, the possession of the collateral that was provided, and they will provide it to the creditor. Under the SARFAESI Act, there is a provision for the establishment of a central registry under Section 20. This central registry or this central registrar, what will be the purpose? So the particulars of every transaction of securitization, asset reconstruction or creation of security shall be filed with the central registrar. So if a question comes like what is the purpose of the central registrar or what information will be filed with the central registrar, so any form of transaction or every transaction of securitization, asset reconstruction or creation of security has to be filed with the central registrar, and this will be in the manner and on the payment of the fee that will be prescribed. Also, under this act, if any person contravenes, attempts to contravene, or abets the contravention of the provisions, then they shall be punishable with imprisonment. Let's say an order has been passed by the authorities regarding the securitization of the property. After that, the holder of the property, let's say the borrower who has failed to repay the loan, they try to transfer the property or they try to sell off the property or move the property. So this will be considered as a punishment, or this will be considered as an attempt to contravene, which will be punishable by imprisonment, which can be extended to 1 year, fine, or both. So these are punishable under section 29. So if any person tries to contravene with the function, the provisions of the SARFAESI Act, then they are punishable. And this is given under section 9 of the Act. Right, so we have seen the manner and the effect of takeover under this Act. Also, any person who is aggrieved can make an appeal. If they are aggrieved by the order that is made by the debt recovery tribunal, then we have seen they can make an appeal to the DRAT. Okay. So when we talk about the central registry, this is as per section 20 that the central government, they can set up the central registry, which will require all the filing of the information that we just discussed. It will also define the territorial limits within which the office of the central registrar may exercise their functions. Then registration of the systems with the central registries, their integration of records with various registration system, all the particulars of creation, modification, satisfaction of security interest, any hypothecation of the plant, machinery, trademarks, copyright, everything will have to be provided to the central registrar. Okay. Yes, I hope this is clear regarding the offences and penalties we have also discussed. So penalties, the section 25 provides that the satisfaction of the charge has to be intimated to the central registry, right? Then the penalties for non-compliance of the directions of the Reserve Bank of India is also there. Offences we have just discussed: contravention, attempt to contravention. And if any such company, they fail to comply with any of the directions that are issued by RBI, then they have to pay a fine. They are punishable with a fine not exceeding rupees 5 lakhs. If they continue to the offense, then it can increase by 10,000 per day. Right? This is not that important, but just for information, we can revise it. Then what is the power of the adjudicating authority to impose penalty? So we have the adjudicated appellate authority as well. Okay. So they will have power to pass such order it deems fit after providing a reasonable opportunity of being heard after the appeal has been taken into consideration. So all of these things are there. Then the section 30 provides that No court shall take cognizance of any offence that is punishable under section 27 in relation to the compliance of the provisions. So if the appellate authority, they give a decision as to the punishment that is to be given to the person who is doing the misconduct or who is liable for the punishment, then no court can intervene in that. They cannot take cognizance except upon a complaint in writing made by the officer of the central registry or an officer of the reserve bank, generally or specially authorized in writing on this behalf by the central registrar. So if the central registrar's officer, any officer of the central registrar or RBI, they file in written or they provide in written that the courts need to take cognizance, only then the courts will intervene, otherwise they will not, right? And we have already seen that any cognizance of the offence will be taken by the metropolitan magistrate or the judicial magistrate of the first class only. No court below the rank of this can take cognizance. So you need to remember which court or which class of courts can take cognizance of the offence punishable. It is the metropolitan magistrate or the judicial magistrate, not below that. Then section 31 gives the details of the excluded securities to which the act is not applicable, like agricultural land. The actions that secured creditor can take against the security are required to be taken within the limitation period, which are in the provisions of the Limitation Act. The time period within which the action can be taken is given in the Limitation Act, section 36 of the SARFAESI. All right, this is there. That is enough from the SARFAESI Act. Next, we have the Recovery of Debts and the Bankruptcy Act of 1993. Okay. So the act is now applicable to the whole of India. It came into force on the 24th day of June 1993. So 24th June 1993, this act came into force. Under this, we have the Appellate Tribunal. It is a body established for the purpose of preferring an appeal against the order passed by the tribunal. So, if a question comes under which act the appellate tribunal is established, we should know it is the Recovery of Debts and Bankruptcy Act of 1993, not the Debt Recovery Tribunal Act. All right. So, the appellate tribunal is established for the purpose of preferring an appeal against the order that is passed by the DRT. It is established under subsection 1 of section 8 of the Act. A person is qualified for appointment as the presiding officer. So every DRT will have a presiding officer and other such officers. What will be the qualification for appointment of the presiding officer? If he is or has been or is qualified to be appointed as a district judge. So this person should have the qualifications to be appointed as a district judge. He holds the office of term for 5 years from the date on which they enter upon the office or until they attain the age of 65 years. So we need to remember the qualification, which is of a district judge. Then we will also remember the term of office, which will be 5 years or 65 years of age. As per section 10 of the Act, a person shall not be qualified for the appointment as the chairperson of an appellate tribunal unless he or she has been qualified to be a judge of a high court, has been a member of the Indian legal service and has held a post of grade of that service for at least 3 years, has held office as the presiding officer of a tribunal for at least 3 years. Alright, so this is the qualification of the presiding officer to be qualified as a district judge, and the chairperson of the appellate tribunal has to be qualified to be a judge of the High Court. Then, from the date of the establishment of the tribunal, that is the appointed date, no court or other authority shall have any jurisdiction. So, these tribunals that are established, why are we talking about these tribunals? Because when the courts they felt, when the judiciary they felt all the cases coming to them, it delayed the taking of decision, or it was a very tiresome process, so they divided their powers. All these DRTs, the Lok Adalats, what we talk about, these are given powers in particular areas related to particular cases so that the courts do not need to intervene in them. All right. So, these tribunals, they have the jurisdiction, power and authority for claims of banks and financial institutions for the recovery of rupees 20 lakhs and above. So, no court or authority shall have the jurisdiction, the power or authority to deal with the cases, that is the claims of banks and financial institutions for recovery of rupees 20 lakh and more. Only the tribunal that is established in this particular district or in this particular area can deal with the cases, right? So, where a bank or a financial institution has filed an application, what can happen? Let's say there are two banks. Both the banks they are facing a recovery situation from this person XYZ. That is, this person owns to both the banks, and this bank has already filed an application with the DRT. So the second bank need not make a fresh application. They can simply add to the application that was made by the first bank. So, where a bank or the financial institution has filed application under the section 19 before the tribunal for the recovery of its debt, and if from the same person another bank or financial institution has also to recover a debt, then such latter bank or financial institution may join the applicant bank in the already filed application at any stage of the proceedings before the final order is passed. So before the DRT takes the decision, any number of banks, if they're aggrieved by the same person, then they can join in the original application that was made by the first bank. This is given in section 19(1). All right. So more than one banks, they can join in the application. Okay. Then in section 20 of the statute, it is given that any person that is aggrieved by the order that is passed by the tribunal or under the DRT Act, they may prefer an appeal to the appellate tribunal. So if they are aggrieved by the decision that is taken by the DRT, then they can make an appeal to the DRAT, that is having the jurisdiction in the matter. However, if the order was made by the tribunal with the consent of the parties, then no appeal shall lie. This can be asked as a case study question. Like they can say that two-person they came into dispute and they decided to uh, take the dispute to a tribunal for mediation or arbitration. Then they came into a consent and they agreed with the decision that was taken by the DRT. However, later on, one of the person they realized that no, this decision that was taken was prejudiced or against their benefit, and they decide to file an appeal. They can not now file the appeal. Why? Because the decision was taken, the order was made by the tribunal with the consent of both the parties. So, no appeal shall lie here if with the consent the order was given. They cannot make an appeal with the DRAT now. All right, so this is how it is done. Moreover, the courts, the higher courts, they can also transfer the pending cases to the DRT if they feel that this case is related to the jurisdiction of the DRT. If the DRT, however, fails to take a decision, if they feel that even after many sessions, a lot of time spent, the people are not coming to an agreement, then they can pass the case back to the higher court, and the court will start from the place where it had left. It will not start the case afresh. All right. So these are certain provisions regarding the transfer of pending cases, which is given under section 31 of the act. Like the issue of transfer of existing cases to the tribunals can be made before the court. All right. Then we have already discussed the chairperson of the appellate tribunal, the presiding officer. Apart from the presiding officer, the recovery officer and other officers are also there. Protection of action taken in good faith. So whenever we are talking about the DRTs, they are taking the decisions not based on any particular rules and regulations, but on good faith or judgment, equality, all of these things. So that is there. Next, we have the Insolvency and the Bankruptcy Code 2016, the IBC Code 2016. So this was a very important act that came into force. Before the enactment of the IBC, there were multiple overlapping laws that governed the various facets of the insolvency process, and there wasn't a comprehensive legal framework to solve these cases or how we can deal with the default. So because of that, the SARFAESI was later on enacted, right? And then improving on that, the IBC came in 2016. And then it has also been amended many times. So when we talk about what is insolvency or what is bankruptcy, insolvency is where the individual or the organization, they are unable to meet their outstanding debt towards the lender. So that is insolvency. We'll say that the individual or the organization has become insolvent. Bankruptcy is, however, slightly different. Insolvency, we just said that the individual or the corporate, they are unable to pay their debts. Bankruptcy, on the other hand, is a legal declaration that they are doing this voluntarily, that either voluntary by the debtor or at the insistence of the creditor. So when bankruptcy is when a person voluntarily declares insolvent. If they're not unable to pay, they're insolvent. But if they're voluntarily declaring that no, I cannot pay the debt to the creditor, then they will declare themselves as bankrupt. All right. And when the bankruptcy has been declared, then the court is responsible to liquidate the personal property of the insolvent. All right. So this is the difference between insolvency and the bankruptcy. And this act includes or governs both insolvency as well as the bankruptcy. Okay. Now, if we talk about the coverage of the act, the statute, it extends to the whole of India. It applies to any company that is incorporated under the Companies Act of 2013, any other company that is governed by any special act, any LLP, limited liability partnership, which is incorporated under the Limited Liability Partnership Act of 2008, anybody that is incorporated under any law for the time being, the personal guarantors to corporate debtors, partnership firms and proprietorship firms, individuals other than the persons that are referred to in the clause. So all of these entities will be covered under the IBC Code of 2016. Apart from this, there are four pillars. The IBC 2016 rests on four pillars. These four pillars are the insolvency professionals, the information utilities, the adjudicating authority, and the Insolvency and Bankruptcy Board of India. Very important. Very important. Who are the insolvency professionals? Basically, we'll say these are people who are appointed with the primary duty to assist in the completion of the insolvency resolution, the liquidation, and the bankruptcy proceedings. All right, so any person who is enrolled under section, we will write it here. You don't need to remember it, just that they are given in the section 206 of the code. So they are responsible to carry out the functions, the steps, the completion for the insolvency and bankruptcy. Then we have the second pillar, which is the information utilities. As the name suggests, they would collect and authenticate and disseminate the financial information. They will create or maintain the electronic database of the lenders and the terms of lending, so that any delay or dispute can be eliminated because correct information will be readily available. So this is the responsibility of the information utilities. Then third very important pillar is the adjudicating authorities. These authorities are under the code of the National Company Law Tribunal. I will write this down here. National Company Law Tribunal, as well as the DRT. So what they are going to do, these authorities under the code, the NCLT and the DRTs, they're relating to the insolvency of the corporate person. The NCLT is related to the insolvency of the corporate persons. DRTs are related to the individuals and the partnership firms. So NCLT will deal with the corporate persons, and DRT, which is the second adjudicating authority, will deal with the individuals or the partnership firms. So these are the appellate bodies. All right. So the educating authorities is there, and then the fourth pillar is the Insolvency and Bankruptcy Board of India, the IBBI. This body has the regulatory oversight over the insolvency professionals, the agencies, as well as the information utilities. So if any mismatch in the information or the function is seen, so there the regulatory oversight will be made by the IBBI. All right. So this is there. Then we have the Corporate Insolvency Resolution Process, CIRP. The CIRP. What is the main function or what the financial creditor can do? First, under section 7, right, under section 7 of the IBC, the financial creditor can initiate the corporate insolvency resolution process. So this section becomes important. Under the IBC code, section 7 becomes important, under which the financial creditor can initiate the corporate insolvency resolution process. Now this process is initiated, the financial creditor, the bank to which the financial debt is owed. So what they will do, they will, the financial creditors who are sure that their particular debt, this particular asset has become a non-performing asset, they can apply for the CIRP. Okay. Then under the statute, time limit has been fixed for the completion of the entire resolution process. A time limit has been set that within this time limit, the process has to be completed. Section 12 deals with this issue. So the time limit is given in section 12. So the corporate insolvency resolution process shall be completed within a period of 180 days from the date of admission of the application to initiate such process. Again, very important. I will write down question can come from him. There's a large chance, a huge chance. So in how many days the CIRP, the corporate insolvency resolution process, has to be completed from the date of admission of the application? Within 180 days it has to be completed. This is given under which section? Under section 12 of the IBC. All right. Then we have the interim resolution professional, which has been included in the definition of a resolution professional described in section 527. What is the definition, or who is the resolution professional? So means an insolvency professional appointed to conduct the corporate insolvency resolution process or the pre-packed insolvency resolution process, as the case may be, and includes an interim resolution professional. So the person, This whole very difficult definition basically talks about the authority or the person who is given the authority and power to conduct the CIRP, to take notice of the resolution process, to conduct the corporate insolvency resolution process. Simple. Who has the responsibility to conduct the CIRP? The interim resolution professional, right? So the section 22 deals with the appointment of the resolution professional. The first meeting of the committee of creditors shall be held within 7 days of the constitution of the committee of creditors. Okay, that is not right. Okay. So the adjudicating authority within 14 days of the receipt of the application, they may ascertain that yes, a default has been made on the basis of the records of the information utilities. Then when the default has occurred, what we'll do, we will move further with the securitization and reconstruction process. If however, can the CIRP be suspended, or can the initiation be suspended? It was done subsequent to the COVID-19 pandemic. So the code was amended to suspend the initiation of CIRP by all the parties, whether they were the financial creditor or the operational creditor or the corporate applicant. So no application for the initiation was filed. This was for a period of 6 months or exceeding, but it was only for the case of COVID-19. Only in the case of COVID-19. Then what do we have? Through the amendment to the Code 2021, the Government of India has introduced a pre-packaged insolvency resolution process for the MSME corporate debtors that are classified under the Section 7 of the MSMED Act. So this pre-packaged insolvency resolution process is for which type or which category of the debtors? It is for the MSME. Okay, very important. So if the paper asks us that this pre-package that was created in 2021 by the Government of India, this was for which class of debtors? So we know it is for the MSMEs particularly. Now, the persons who are not entitled to make an application under the resolution process for the initiation of the CIRP, any corporate debtor that is undergoing an insolvency resolution process, obviously, then any financial creditor undergoing a pre-packaged insolvency resolution process, if they're already under a insolvency resolution process, then they cannot make an application under the IBC. So any corporate debtor cannot make the initiation, they cannot make the application. If for example, let's say a corporate debtor against whom a liquidation order has been made, and towards correcting their own finances they are trying to make an application, they cannot do so. So when the application is being accepted, these things are taken into consideration. Then there is the time limit which is fixed, 180 days. However, the period can be extended if the resolution professional says so, if they file an application to extend the time period, right? Then what else is important? We have seen what is the resolution professional. Liquidation, when we talk about the liquidation, so section 33 talks about the liquidation process: enforcing or realizing, compromising with the security interest. So liquidation process will take place if there is a failure to submit the resolution plan, or if the rejection of the resolution plan has been made, or the creditors committee, based on the vote of majority, they are taking a decision to take the liquidation process. So all of these things are there. Even the corporate person can ask for voluntary liquidation, who intend to liquidate it, the voluntary liquidation proceedings. and they have not committed any default and they can pay off the debt, but they themselves are requiring or volunteering towards liquidation. So that can also be done. All right. And for this, obviously, the central government has also introduced the fast track insolvency resolution process and the pre-packaged insolvency resolution process, which is meant for the MSMEs. Okay. Next act that we are going to discuss is the Bankers Books Evidence Act. So this particular act, which was enacted in 1981 to amend the law of evidence with respect to the banker's book. So before the enactment of the act, what governed the banker's books? It was the law of evidence. And then the Bankers Book Evidence Act was enacted. Yes, so now let us start with this particular act. As per section 2A of the statute, when the books of the bank are not handwritten and copies are taken by a way of printout, then how will the copy be certified? When we talk about the various applications or applicability of the definition, so we know it is applicable on a company, it is applicable to the whole of India, and bank or banker, the regular definition, any company that is carrying on the business of banking, partnership or individual, any post office saving bank will be included. If we talk about the bankers books, so what all will be included? The ledgers will be included, the day books, the cash books, account books, all the records that are used in the ordinary business of the bank, all of these will be included in the bankers book. All right. And if we talk about the legal proceeding, so any proceeding or inquiry in which the evidence may be given, the banker's book can be given as an evidence. That will be called as the legal proceeding. Also, where the certified copy, we are talking about the certified copy, where if it is maintained in the written form, then certified copy will be the true copy of such entry. However, if it is maintained in the electronic form like printouts or data stored in the floppy or tape or any electronic data storage device, then a copy of such printout, and it should contain the certificate having all the applicable contents, right? So this is given under section 2A, that if the books of the bank are not handwritten, if they are in the electronic form, let's say, or in the mechanical form, let's say, then the copies are taken by a way of printout. So this copy must accompany what? Along with this copy, there should be a certificate by the principal accountant or the manager to the effect that it is a printout of such entry or a copy of such printout. So a copy, original copy has to be provided, right? A copy of the original handwritten or books of the bank has to be provided, and it has to be certified. Who is going to be the certifying authority? Either the principal accountant or the manager. They will provide the certificate, and a certificate by a person or a person who is in charge of the computer system. So a certificate will be provided by a person in charge of the computer system containing a brief description of the computer system and the particulars. So why we are discussing this? Because if the copy, the book of the bank are not handwritten, and if they have to be provided as evidence in any particular case or trial, then along with the copy, the certificate should be provided. This certified copy of any entry in the banker's book in all the legal proceedings be received as prima facie evidence. The court cannot reject the copy stating that it is not the original one. All right. So they will accept it as an evidence if the copy is certified. Further, it shall be admissible as evidence of all the matters, transactions, and accounts therein recording in every case as the original. So the all the, we'll say, power that is held by the original entry itself, same will be there in the certified copy of any entry in the banker's book. Right? So this is there. Then according to section 5 of the act, any proceeding where the bank is not a party, no officer of a bank shall be compellable to produce any banker's book, contents of which can be proved used under this act by the production of certified copies. Again, very obvious. If the bank is not a party to the proceeding that is being undertaken in the court, the act or any authority under the act cannot force the bank or any officer of the bank to produce any banker's book, nor can they force them to provide as witness in the court. Right? So any person that is not involved, if the bank is not involved with the proceeding, that they cannot be compelled to produce the banker's book. All right. So this is also there. But obviously the court can make an order if it is a special case. Even where a bank has itself filed a suit for the recovery of dues, then also the original documents need not be produced in the court unless the documents are disputed. They can then also provide the certified copy. Right? So it will be received as the prima facie evidence. The certified copy of the entry will be received as a prima facie evidence. Now, in terms of the provisions of Section 7, the costs of an application to the court under or for the purpose of this act and the cost of anything done or to be done under the act shall be in the direction of the court. So, any cost that is undertaken by the bank for doing anything or following the order of the court will be at the discretion of the court. The court can also order inspection of the books of accounts. The order of inspection must give 3 days clear notice to the bank for arranging of the inspection. So, one of the application of this particular act is that the court or a judge, they may order that the bank should provide for the inspection such and such evidence or such and such, let's say, information or books or entries which is accompanied by a further certificate. They can do so in a special case also, even when the bank is not involved. But for that, they have to provide 3 clear days. Clear days means it is exclusive of the bank holidays. Okay, so an order under this will be made either with or without summoning the bank and shall be served on the bank 3 clear days. The bank may at the time before the limited time, they may give or produce the order, or during the time of the trial they may produce their books, or they can also give notice of their intention to show cause against such order. All of these options are available. What we need to remember here is that how many days are given for the banks for the by the court to the banks for the arrangement of inspection. 3 clear days. 3 clear days. Why I am putting emphasis on these information? Because different types of questions are asked. MCQs with options or question without option, fill in the blanks can also be asked. So these type of statements can directly be asked in the fill in the blanks. The order of inspection of books must give dash clear days for the bank to arrange for the inspection. You'll be given options as 3, 4, 6, and you'll have to choose. So 3 clear days. All right. Similarly, where we have seen in other acts also, like for filing an appeal, how many days is there that you cannot file the appeal after these many days or after the order made by the, let's say, DRT under the act. So this is there. Then we have the Legal Services Authorities Act. The Legal Services Authorities Act. One question that was asked in the previous examination, under which act is the Lok Adalat organized? And the options were given as the LSA Act, even Lok Adalat Act, and many aspirants, they were confused and they marked the Lok Adalat Act. But that is not true. The Lok Adalat Acts are organized under the Legal Services Authorities Act of 1987. Very important. Don't get confused in the examination. All right. Don't get confused that it comes under the Lok Adalat Act. No, it comes under the Legal Services Authorities Act. So, as per Section 19, subsection 1 of the Legal Services Authorities Act of 1987, the Lok Adalats are organized by the state authority, the district authority, or the Supreme Court Legal Services Committee, or the High Court Legal Services Committee, or the Taluk Legal Service Committee. So these Lok Adalats can be established or organized at different levels. At the state level by the state authority, at the district level by the district authority, the Supreme Court Legal Services Committee can also establish it, the High Court Legal Service Committee, or at the Taluk level, the Taluk Legal Service Committee, at such intervals and places for exercising the jurisdiction and for such areas as it thinks fit. So, Lok Adalats are established for those cases that do not require particular involvement of the court, and they can be solved at these decentralized levels. We will see which type of courts can be brought, which type of cases can be brought under the Lok Adalats. So these are the various authorities that can organize the Lok Adalat. And obviously, if in a particular district these types of cases arise more, any disputes related to uh, the Lok Adalat authorization, there more Lok Adalats will be established and in more frequency. Now, when we talk about which type of disputes, the definitions. So, when we are trying to determine and arrive compromise, at a compromise or settlement between any two disputed parties, this will be the jurisdiction of the Lok Adalat, right? So the dispute should be either a pending case before any court for which the Lok Adalat is organized, or any matter which is falling within the jurisdiction but not pending in the court. So two options we can see here: either the case is under the original jurisdiction of the Lok Adalat, or it is given by the court, any higher court. They are saying it is a case that is pending before any court, and they're saying that the Lok Adalat can solve it through compromise and settlement. Then also they can refer the case to the Lok Adalat. So the offences which are compoundable under any law cannot be brought within the purview of the Lok Adalat. Very important. Okay. So the cases which are compoundable under any law, they cannot be brought within the purview. So you can be given options. Which of the following fall within the jurisdiction of the Lok Adalat? So any case within the jurisdiction not pending in the court, any case that is pending in the court, or any non-compoundable case, they fall in the purview. But compoundable under any law cannot be given under the jurisdiction of the Lok Adalat. Then there's also monetary ceiling of the amounts that can be settled under this mechanism, which is rupees 20 lakhs. So within this limit, the cases can be given to the Lok Adalats for the compromise. So the cases where the dispute amount presently is rupees 20 lakhs, they can be settled. Now, what is the function? The Lok Adalats shall arrive at a compromise or settlement between the parties. They shall act with utmost expedition to arrive at a compromise, and they shall be guided by the principle of justice, equity, fair play, and other legal principles. So the Lok Adalats, using the principles of justice, equity, fair play, what they're trying to do, they're trying to reach at a compromise. They're trying to, the parties that they settle, they reach a compromise regarding the dispute, which is not more than rupees 20 lakhs. So this is what the whole information says. Now, whenever we are talking about the Lok Adalat, they should have members. Every Lok Adalat that is organized for an area should have serving or retired judicial officers, any other person that are stated or specified by the state authority or the district authority, the experience and qualifications of the other persons. It is also given in the act. Accordingly, the people will be included, right? So this is there. Regarding the cognizance, can any other court take cognizance of the cases by Lok Adalat? So no. The award of the Lok Adalat shall be deemed to be a degree of a civil court or an order of any other court. The award or the decision that is taken under the Lok Adalat, it will be the degree of what? Degree of a civil court or an order of any other court. This is given under section 21 of the Act. But the section 20 is also there, which states that the with the cognizance of the cases by the Lok Adalat, and it also states that it deals with the cases like which types of cases are dealt, the disputes that the parties agree to refer themselves with their consent, they want to bring the dispute to the Lok Adalat, dispute where one party makes an application to the court to refer to the Lok Adalat themselves, right? Dispute where in the opinion of the court they are thinking that it can be taken cognizance by the Lok Adalat, where there's a potential dispute and the Lok Adalat can receive the application on the basis that a compromise can be reached between the two parties, right? So we have seen how the Lok Adalats will deal with the cases trying to reach a compromise or settlement. Then the decision that is taken by them will be of the decree of a civil court or an order of any other court, and no appeal shall lie in any court against that. So this is what I was telling you about. Every award shall be binding on the parties. It will be binding on the parties and no appeal shall lie in any court. So the powers of the Lok Adalats are derived from the Legal Services Authorities Act. The Lok Adalat or the permanent Lok Adalat, they can summon and enforce the attendance of any witness. They can ask for the discovery and production of any document. They can ask for the reception of evidence on the affidavits, public record, document or copy of any such record. All of these powers are provided to the Lok Adalat, right? And these are deemed to be judicial proceedings, right? So the Lok Adalats have sufficient powers to take on the cases. Next, we move on to the Consumer Protection Act of 2019, which aims to provide protection to the interest of the consumers, to establish authorities for the timely and effective administration for the settlement of consumers' disputes and any other matter that is related to it. So this was enacted on August 9, 2019, and it came into force from July 20, 2020. Came into force from 2020. Now let us see certain definitions. The definitions of the major terms appearing in the Act are given in the section 2 of the Act, right? Section 2 of the Act, where the complaint can be related to the bank. So the branch office means any office or place of work that is described by the complainant. The central authority that we are going to talk about will be the Central Consumer Protection Authority. We will see, right? It is given right here. The Central Consumer Protection Authority or the Central Consumer Protection Council. Complainant will be the consumer, uh, or it can be the central government or the state government, central authority, one or more consumers, and so on, right? Complaint will be any allegation that is made in writing by the complainant. Now when we talk about the unfair contract, where the unfair trade practices or a restrictive trade practice has been adopted by the trader or the service provider. Let's say the goods that were bought by the consumer, they were having certain defects or they were not according to the description that was provided, or the services that were hired to or availed were again not of the good quality. So what can the person do? They can file the complaint. So here, unfair trade practices means a trade practice which for the purpose of promoting the sale, use or supply of any good or for the provision of any service adopts any unfair method or unfair or deceptive method. Now let's say any company, any let's say soap manufacturing company, they create a commercial or ad in the newspaper or TV wherein they are given some unrealistic achievements or assumptions, but they're not making a guarantee. This will not be termed as an unfair trade practice. Unfair trade practice will be termed as when they're using a trade practice for the promotion of sale that is unfair. If they're using force to promote, or if they're using let's say they're saying that this particular product is from doctor's guarantee or any such thing, then that will be termed as the unfair trade practice. So we'll see further how can we differentiate between when the complaint has to be accepted or not, right? So for this, in section 3, 4 and 5 of the act, establishment and working and objects of the Central Consumer Protection Council has been given. So the central government will establish with effect from such date the Central Consumer Protection Council. This will be known as the Central Council, right? So consumer has right to be informed about the quality, the quantity, standard price of the goods. They also have the right to be assured that the variety of goods, the quality will be followed. They have the right to be heard, and they have the right to seek redressal against any unfair trade practice. Also, they have the right to consumer awareness. Defect will be meaning of any imperfection or fault. Deficiency will be shortcoming, and mediator, mediation, all of these things are there. Okay, so unfair contract is given in section 246, right? Like requiring the excessive security deposits to be given by the consumer, imposing any penalty on the consumer. This will be termed as unfair. Refusing to accept any early payment, or permitting one party to assign the contract to the detriment of other party. These are all the unfair contracts that we can discuss and the consumer can complain against. Then unfair trade method or unfair method or deceptive practices, like falsely representing the goods are of a particular standard, or that the services are of a particular standard, or all the goods or services have sponsorship or approval from a approving agency like medical agency. Misleading information is provided. Any warranty or guarantee on the performance, that is false. So all of this can be termed as unfair trade practices. Any advertisement that is made in the newspaper or TV, anywhere. Permit like right. So I think this is enough. Then we have the central, state, the district Consumer Protection Council. We have already seen that the Central Consumer Protection Council, which is established by the central government under the section 3, 4 and 5, right? They will consist of the minister in charge of the Department of Consumer Affairs in the central government, and any such members that may be prescribed. Then we have the State Consumer Protection Council, which is established under Section 6 of the Act. Every state government by notification will establish this particular council, which will be known as the State Council. So 3, 4, 5 for the central, 6 for the state. Then section 8 and 9 talks about the establishment of the District Consumer Protection Council. Here the state government shall by notification, again this is the responsibility of the state government to establish the district council. Then we also have the District Consumer Disputes Redressal Commission. The state government again shall establish, provided that the state government deems fit to establish more than one district commission in a state. So if the state government deems fit, they think that it is required, then they can establish more than one district commission in a state as well. And then there are various provisions related to each of these councils, like the meetings. When shall the meetings be held? Not less than two meetings shall be held every year. So maximum meetings are not stated, but minimum two meetings should be held every year. Then time and place, which is decided by the chairperson as they deem fit. The meetings will be consisted, or the advisory council will be consisted, like if we are talking about the district consumer protection council, so the collector of the district will be the chairperson or any other person. Then state, if we are talking about, so the minister in charge of the consumer affairs in the state government, at the national level of the national government, and so on, right? We also have the State Consumer Disputes Redressal Commission. Then, yes, this is important. Under Section 53, the establishment of the National Consumer Disputes Redressal Commission is given. We have seen the State Consumer Disputes Redressal Commission under Section 42. We also have the National Consumer Disputes Redressal Commission under Section 53. So, what will be the responsibilities of these dispute redressal commissions? Like regarding the complaints that shall be filed at the district level or at the state level, this committee will include a president, not more than two, not less than two, and not more than any such members that are given by the state government. I don't think all of this is important. Basically, their functions to entertain the complaints where the value of the goods and services they exceed rupees 1 crore will come under the state consumer disputes redressal, right? So they are going to entertain such complaints. Then what else? Regarding the national consumer dispute redressal, if the complaints where the value of the goods exceeds rupees 10 crores, then they will come under the jurisdiction of the national consumer disputes redressal, right? So they can call for the records and pass appropriate orders. Their jurisdiction, powers, and authority will be as termed by the bench that is constituted for it. When the members they feel they can appoint and they can hold on a meeting, and that is all I think that is important. So, jurisdiction of the district commission, the state commission, and the national commission. Then, regarding the finality of the orders and the limitation period, then it states that the district commission and the state commission, no appeal has been preferred against the orders that are made by them. So, their orders will be final. And if we are talking about the penalties or we are talking about the limitations, so within certain time period they have to take the decision, and the reference or award that are made, they will be the decree that will be constructed under the act. So this is there. Okay, next we have the law of limitation. The law of limitation, which tells us about the prescribed time period. The prescribed time period. So, Section 3 of the Limitation Act declares that every suit that is instituted, appeal that is preferred, and application that is made after the prescribed period shall be dismissed, although the limitation has not been set up as a defense. So, limitation tells us the time limit, that within which this time limit the suit or the appeal or the application has to be dissolved or resolved. After that it cannot be done. This is the main purpose of the limitation act, right? So the entities where they're providing the financial assistance, or where we are talking about the recovery of debts, or we are talking about the IBC code, there are certain time limits which are given. Within the period of limitation, the claims or the awards have to be made, right? So definitions that are given under the limitation act, it includes the petitioner or the person who is making the application, that is the applicant. Then defendant will be any person from or through whom the defendant derives the liability to be sued, right? Then we use the term plaintiff here. The plaintiff term or plaint term is also used. What is the meaning of these terms? So plaintiff will be any person from or through whom a plaintiff derives the right to sue, right? So the period of limitation is always in relation to the right, whether arising out of a document which entitles the person having the right or the beneficiary to take an action in the court of law. So this is the prescribed period. Next, what do we say? The suit is said to be instituted when the plaint is presented to the proper officer in the court. When the complaint is presented to an officer in the court, then we say that the suit has been instituted against the person who was responsible, who was liable. So in the case of a set off or counter claim, those shall be treated as a separate suit and shall be deemed to have been instituted. If in a case of set off on the same date as the suit in which the set off is pleaded, or in the case of a counter claim on the date on which the counter claim is made in the court. So if this person now makes a counterclaim. So this will be treated as a separate suit. It will not be included in the suit that was originally made in the court. So suit is said to be instituted when the complaint is presented to the officer. And if a set off or counterclaim is made, then it will be treated as a separate suit. It will not be included or it will not be deemed in the original suit that was made. Right? Then we talk about the computation of the limitation. So it is absolutely necessary that every suit or application shall have to be filed within the period of the limitation that has been stated. For every suit, every appeal, or every application that has been made, right? Now, if we take the computation of the period of limitation, so when a period of limitation expires on a day when the court is closed, then the suit that is instituted, appeal that is preferred, or application that is made on the day when the suit reopens. Alright, so if the period of limitation is expiring but the court is closed on that day, so when the court will reopen, then the suit will take place in the court. Alright, if any appeal or any application other than the execution petitions may be admitted after the prescribed period, then if the appellant or the applicant makes sufficient cause. So after the limitation period or after the prescribed period, there's also an option to make the appeal or make the application if the appellant or the applicant makes out sufficient cause for not preferring the appeal or application within the period of limitation. If they state reason a reason that is valid, that because of this reason they were not able to admit, or they were not able to make the suit, then they can do so after also, but they have to provide a valid reason in writing for that. All right, then what else? In computing the period of limitation, the day from which such period is to be reckoned shall be excluded. So the first day will be excluded when we are calculating the period of limitation. Then for an application for the execution of decree, the period during which the institution or execution has been stayed by an order will also be excluded. So if, let's say, during the process the execution or institution has been stayed, they have been put on rest, or they have been uh, on for a temporary period, they have been stayed, or a stay has been put on it, then this period will be excluded. Then for filing any suit for which the notice has to be given, or for which the previous consent or sanction of the government is required, then this time period which was required for obtaining the consent or sanction shall also be excluded. So if a sanction or consent of the government is required for the filing of the suit or for making of the application, anything at all, then the time period that was required for obtaining such consent or sanction shall be excluded. And finally, in computing the period of limitation, the time during the defendant has been absent from India. They are outside India, they're not in the territories of India. This period shall also be excluded. So here we will write down for the computation of the limitation period what all will be excluded. So first we saw that if the court is closed, then that day will be excluded. Then we saw that if the person making the application provides a valid reason, then third reason is that during the period, let's say, on which the limitation is started, the period is reckoned. So the first day we will term it as the first day. Then the fourth option is when a stay has been created, when the court has, let's say, ordered a stay on the decision or functioning, then the time required for the sanction or consent of the government will be excluded. And finally, if the person is not present in India, if the person is absent. So after excluding this time period, then we will compute the limitation period. All right. Yes. Then what are the acts that give rise to a fresh period of limitation? We just said that if a person gives a valid reason, so there are certain instances which give rise to a fresh period of limitation. So when before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement of liability is provided. An acknowledgement of liability in respect of such property or right has been made in writing, and also it has to be signed by the party against whom such property or right is claimed, or by any person through whom he derives the title or liability. Then a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. So if an acknowledgement is created, first reason or first condition where the fresh period of limitation can be initiated is when, with respect of the property or right, an acknowledgement of liability in writing has been signed by the party against whom the property or right is claimed. Then a fresh period of limitation can be initiated. Second reason, where the payment on account of a debt or of interest on a legacy is made before the expiration of the prescribed period. So before the expiration of the prescribed period, the payment on account has been made by the person that is liable to pay, or the legacy, or by the agent duly authorized, then a fresh period of limitation shall be computed from the day or time that the payment was made. So if this person makes a payment, then a fresh period of limitation will be initiated. So there are two conditions: either acknowledgement of liability in writing signed by the party, or a payment is made by the person before expiration, then it will give rise to fresh period of limitation. All right. So there are certain important provisions in the Schedule to Limitation Act which we need not remember, like for the balance of due on a mutual loan, 3 years period of limitation is there. Then for the money payable towards the money lent, again 3 years is there. Then what is about, for a mortgage we have studied limitation period is 12 years. For a mortgage by foreclosure, the limitation period is 30 years. But again, we need not remember everything. The things that we have studied under a particular law or a particular act, like if we want to appeal a file in the if we want to appeal in the high court against a judgment of a lower court, then 90 days time is given. If we want to file in the court against the judgment of a lower court in any other court except the high court, then 30 days time is given. So we will see the limitation period in terms of the acts or laws that are covered, but not other than that. It is not important for our examination. Next, we move on to the tax laws which is the last law or last chapter of our module C. In the tax laws, we have the income tax, we also have the GST, the commodity transaction tax that we are going to cover in short. So, Income Tax Act came into force in 1961. It came into force from April 1st, 1962, and it extends to the whole of India to govern the law related to the taxation of income on individuals, corporates, etc. So, all the people in India, whether we are talking about individuals or we are talking about the corporates, they need to pay income tax. Accordingly, it extends to the whole of India. The Act envisages taxation of income of an assessee on the basis of his residence and the place of source of income. Whether the person that we are talking about is a resident, and what is the place of source of income? This source of income doesn't mean the income that is only earned in India, but if they hold property, if they hold interest outside of India, and from that also they are earning income, will that be included in the income tax? So income that is not really elaborately defined in the act. It basically means the profit and gains, the dividend, any voluntary contribution that the person makes towards the trust, towards themselves, right? Any profit in terms of the salary, allowance, or benefit that they receive, value of any benefit or perquisite convertible into money or not, all of these things are included in the income. It also includes various other things, but again, we need not remember that. Then, when we talk about the assessment year and the previous year, very important. You can simply recall it from when you were studying for the JAIIB examination. What is the assessment year and what is the previous year? And we also studied there the financial year. So the income that is accruing, arising to a person, this is called the assessee. Whenever we are talking about the person to whom or for which we are talking about the income, that is the assessee. It is taxed on the base of the assessment year. So income tax, it is assessed not on the basis of previous year but assessment year. This assessment year represents the period of 12 months beginning from 1st April every year. The income that is arising in the previous year and the tax paid thereon, including the tax that is deducted at source, the TDS, self-assessed tax, and that is paid will be assessed in the assessment year. So assessment year starting from 1st April every year. Assessment year starting from 1st April every year. Previous year will be the immediate financial year preceding the assessment year. So if we are talking about the assessment year 2024, 1st April 2024 to 2025, this will be the assessment year. Previous year will be the year 2023, April to April 24. Now, what is of importance to us is that the income will be assessed in this assessment year starting from 1st April every year. And previous year will be the financial year immediately preceding the assessment year. When we talk about the total income, so income that is received in India or income that is deemed to receive in India, or it is coming from outside, a person is receiving income from outside, will also be included in the total income. So income arising outside India, it shall not be deemed to be received in India within the meaning of this section, but it will be taken into account in the balance sheet. So it will be included in the total income, right? So this is there. If we talk about the residential status, it is dependent on the basis of the number of days that an assessee was present in India during the previous year, right? So that is there. A person resident in India will be taxed. Then under the IT Act, other norms are also there, like quoting the PAN for the opening account, purchase of the DD or term deposit, declaration in the form 60 and 61 we already know, repayment of the term deposit. All of these things are there. When we talk about the computation of income, so the salary, income from house property, profits and gains, capital gains, income from other sources, all of these things will be included. However, which income will not be included in the taxable income, right? So agricultural income as given by the government, then this is subject to any sum that is received as a benefit, as a subsidy, that will also not be included. So agricultural income has been exempted from the calculation of total income. All right. Then if we talk about the commodity transaction tax. So the commodity transaction tax was introduced under the chapter 7 of the Financial Act 2013. Here in section 116 states that commodities transaction tax means the tax that is leviable on the taxable commodities transaction under the provisions of this chapter. So commodity transaction tax, what we are going to remember here is the taxable commodity. What all commodities are taxable are covered under the chapter 7 section 116. So appellate tribunal that is constituted under the income tax act, the assessing officer will be the income tax officer or the assistant commissioner of income tax. Then commodities transaction tax means the tax that is liable on the taxable commodities, like the commodity derivative that we are talking about, a contract for the delivery of goods, a contract for the differences like underlying goods, for the related services. Okay, so that is included in the commodity. So when we talk about the commodity transaction tax, which authority is required to collect the tax? It is the recognized stock exchange. So the law makes the recognized stock exchange dealing in the commodity trading responsible for the collection of the commodities transaction tax from the seller who enters into a taxable commodities transaction in that recognized stock exchange at the rate specified. So the seller of the commodity that we are talking about, the derivatives that we are talking about, they are going to sell these commodities on a stock exchange. So this recognized stock exchange, it will be the responsibility of the stock exchange for the collection of the commodities transaction tax from the seller, right? So whose responsibility? The recognized stock exchange. Then the commodities transaction tax, which is collected during any calendar month in accordance with the provisions of subsection 1, shall be paid by every assessee. And this will be done by the 7th day of the month immediately following the said calendar month. So if we are talking about the November month, so before 7th December, the commodity transaction tax has to be collected, and it shall be paid by every assessee to the credit of the central government, right? So before 7th of the month. Then any assessee who fails to collect the tax in accordance with the provisions, then they will be liable to pay the tax to the credit of the central government. All right. So these are the various conditions. Now, if we talk about the goods and services tax, it is nothing new. We already know in detail about the GST. It is one indirect tax for the whole nation. It has replaced various indirect taxes that were earlier existing, like the VAT, service tax, and so on. So GST is a one indirect tax for the whole nation, enacted on 12th of April 2017, came into force in India from July 8th 2017. It is a single tax on the supply of goods and services right from the manufacturer to the consumer. Earlier what happened, the taxes were computed or collected at various stages. This led to the problem of double counting double counting. So to solve this problem and to increase the tax compliance, what was done? All the indirect taxes were now replaced by the GST. So whether we are talking about the VAT, the SAT, or the luxury tax, purchase tax, or state level entertainment tax, all of these are subsumed by the GST. So the final consumer will thus bear only the GST that is charged by the last dealer in the supply chain. The consumer will not pay. What I just said earlier, what happened at various stages of the manufacturing and by the time the good reached the consumer, the taxes were to be paid. So double counting was there. But now in GST, only when the consumer is finally consuming, then they have to pay the GST. All right, so it is easy to administer, there are better controls on the leakage, it has a higher revenue efficiency. The consumer, it has benefits like single and transparent tax they have to pay, there's a relief in the overall burden. So all the taxes that are subsumed under the GST, the central excise duty, additional duties of customs, octroi, entry tax, when we are talking about exports and imports, luxury tax, all of these are subsumed. Now we have the GST, which is levied by the center on the intrastate supply as well. It is known as the central GST, and that is levied by the state or union territory. It is known as the state GST or the UT GST. Similarly, we also have the integrated GST for the interstate supply of the goods and services. So various levels of GSTs are there. If we talk about the imports in the GST regime, so the imports are specifically defined under the IGST, the Integrated Goods and Services Tax. That is, the IGST 2017 refers to the supply of any service where the supplier is located outside of India and the recipient is located inside of India. So when we are talking about the import, right, so the import, all the taxes will be covered under the integrated goods and services tax, right, and the place of supply of service is in India. So if a question comes like the import of services have been defined under which of the following GST, so integrated GST is the correct answer, right. So yes, okay, that is all from this particular chapter. Next we move on to module D. If you have any doubts or queries related to the tax, the laws and acts that we have studied till now, you can ask it in the comment section. Okay. Now we move on to another very important module, the module D, in which first we are going to discuss about the various terms and conditions, the various requirements and components of a contract. What makes a contract a legal contract, a valid contract, or what will make it a void or voidable contract. Many questions are asked, even I can say maximum questions are asked from module D, right? So when promises are made by one party to another, and when these promises are legally binding, then we might say that we are talking about a contract. So contract means an agreement that is enforceable by law, meaning that the rights and obligations are arising out of the contract and they must be enforceable in a court of law. When we are just talking about an oral promise, it is not a contract. Why? Because this promise cannot be enforced in a law. But when this promise along with itself carries something that is known as an enforceability, then we will say that yes, it is a contract, it has certain rights and obligations that will fall on both the parties that are coming into the contract, and they have to fulfill those rights and obligations. So the agreements between two or more persons, they should be made with free consent of all the parties. Then the party should be competent, like they should not be of unsound mind. They should not be a minor. Only people of the majority age, when they are major, when they are 18 years and above, when they're adults, only their contract will be termed as a valid contract. Then it is made for a lawful consideration. It should not be made for any illegal activity. It is made with a lawful object, and it is not declared as void explicitly in the Indian Contracts Act. So these are the various characteristics of a contract. They should be made with the consent. The parties should be competent. There should be a lawful consideration. Then there should be a lawful object, and they should not be declared as void. All right. So when one person signifies to another person his willingness to do or not do something, when they are telling the person, let's say person A and person B, person A tells person B that I am willing to sell my car to you. All right. And the person B says, okay, I am willing to purchase this car from you. And the price has been discussed earlier itself. Then we will say that they are obtaining the consent and we are making a proposal. If I'm trying to sell my car at second hand at rupees, let's say 2 lakhs, and the other person is saying, okay, I will purchase the second hand car at rupees 2 lakhs, then what we are saying, I'm making a proposal, other person is accepting the proposal, giving me the consent, and thus we will say a proposal has been made. All right, now this is said to be have a made a proposal. Now when a proposal will be given a lawful consideration, before that, when a promise, when it is accepted, we will write it here, when a promise is made and it is accepted, then it will be known as a proposal. When this proposal involves certain law or enforceability, then it will be known as a contract. All right. So here the person making the proposal again is known as the promiser, and the person accepting the proposal is known as the promisee. Word ending with OR and word ending with double E. Now if we see the definition of the contract, an indication of the essential elements of a valid contract is provided in the section 10 of the Indian Contracts Act of 1872. All agreements are contracts if they are made by the free consent of the parties that are competent to contract for a lawful consideration with a lawful object and are not expressly declared to be void under the Indian Contracts Act. That is known as the valid contract, right? Valid contract. Now, proposal and acceptance, we have already said proposal will be made by a person. Let's say they are trying to making a proposal to sell a car, and so this person will become the promiser. The other person B, accepts the proposal, they will become the promisee. This is going to result in the proposal being accepted and the contract being formed. All right. Then there should be an intention to create a legal relationship. Like if the person, the promiser and the promisee, or if the promisee, they say that only orally you are telling me this, or only written way you are telling me this, you're not giving me a stamp that it will be legally enforceable. Like what if I give you the money and you reject it and you say, no, I don't want to sell my car? What will happen then? So a legal agreement has to be signed. So that is the intention to create a legal relationship, right? Also, the valid contracts, they can be made through oral agreements. When can valid contracts be made through oral agreement? They are made in oral, but they have to be in writing only, and they are also required to be registered or attested. Valid contracts cannot be made orally, right? So if it is not written, if it is not registered or stamped, we will not say it is a valid contract. What is the meaning of lawful consideration? When both the parties are agreeing to give something to one another and get something in return, then the agreement is for consideration. If I am giving my car, I am receiving money for it in return. So that is why it is a consideration. If I'm only giving my car as a gift and not expecting or getting anything in return, then it will not be a consideration. All right. So something to get and something in return, then the agreement is for consideration. Right. So, like for example, if someone out of love promises to give a gift to another person, this is a valid contract even though there will be no consideration in it. So it is not necessary that a consideration be there. If return is happening, exchange is happening, then we will say there is a consideration in the contract. But even if the consideration is not there but the promise is made, then also we will say that yes, the contract is valid, but this has to be done voluntarily. It is voluntarily. So next, what we talked about the lawful object. This activity should not be illegal or immoral or opposed to public policy. It is lawful unless it is forbidden by the law. So these are the things. And fine and genuine consent should be there. You should not force the other party to accept to the contract. There should be certainty and possibility of performance, and the agreement should not be declared void under the Indian Contracts Act. Now, what else is here? Yes, very important. What is the meaning of void ab initio? Void ab initio. Such contract will forever be void, which is made by a minor. Which is made by a minor. All right. Void ab initio means an agreement that is made by a minor and it is void. So there should be a lawful consideration for both the parties to agree to enter into an agreement. Consideration here means something in return. I'm giving you something and I'm getting something in return. Then competent to contract means that they are of the age of majority and they are of sound mind. They're not disqualified from contracting by law. They're not under prison. They're not in the prison. Right? So these are the competent people who can enter into the contract. So these are the basic components, these are the basic terminologies. Now when we talk about Contract Act and the bank, so all the bank or banking services, procedures, transactions, in one way or the other, they are a form of contract only. And banking is a trust based relationship. So when a person is coming with money to deposit in the bank account, we in turn are giving them certain interest that is paid. Or if we are giving out a loan, they are paying at interest or they are keeping the security. So there's an exchange. So acceptance of deposit, lending, investing, all of these things can be termed as contract. So relationship between the bank and the customer, when it becomes of a creditor and debtor, whether secured or unsecured, we will consider it as a contract. Next, we will talk about the different types of contracts. First, we have the contract indemnity. Indemnity. Okay. We will use the term insurance and surety here when we talk about indemnity. So let's say it is a contract in which one party promises to save other party from the likely loss. For example, let's say a contract is between person A and B. A contracts to indemnify B against the consequences of any proceedings which C may take against B. So this is a contract of indemnity. So three people are involved. Between two people, a person, third person is going to act as the indemnifier or the surety. So the indemnity holder will be the promisee or the person who is indemnified. So this person, promisee, and has the following rights against the indemnifier. When a legal action is taken against the person who has been indemnified. Alright. So the indemnity holder will be the promisee or the person who is indemnified. Indemnity holder will be the promisee and they will have certain rights against the indemnifier. So what is happening here is that all the damages which the person, the indemnity holder, may be compelled to pay in the suit in respect of the manner or all the costs that he may be compelled to pay in a suit, all the sums in compromise, or the rights to sue for specific performance, what we are doing here is we are providing an indemnity to the person, to the promisee. So the indemnity is provided to whom? The promisee, who is indemnified, who is the indemnity holder, right? For example, if we take an illustration, let's say Mr. A contracts with C. Mr. There's a contract between Mr. A and B, and A is now contracting this person C that B will not sue C in respect of rupees, let's say 1 lakh, which C owes to B. And if in any case B does sue C and the consequences are there, then they will be borne by A according to the contract. All right. So this will be a valid contract. If I clear it down and write it again to make it clear, there are person A, B and C. A, B and C. We are saying that A is entering in a contract with C. A is entering in a contract with C. This contract is of indemnity, that B will not sue in respect of any fund that C owes to B. So C owes certain money to B and B will not sue this person. B will not sue this person in respect of this amount. And if B sues this, then A, according to the contract, will provide as the indemnity. Alright. So a contract of indemnity may be expressed or implied depending upon the circumstances of the case. Like if the persons, they are expressively stating that yes, these and these are the cases where I will provide you indemnity, that will be the expressed indemnity in writing. Implied indemnity will be something that is just taken or assumed. So implied indemnity will be something that is not covered in the contract. The Indian Contract Act only tries to cover or only takes into consideration the expressed indemnity, that is specifically expressed, not the implied indemnity, right? So this is there. Then regarding the enforceability of the contract of indemnity, the Indian Contract Act does not state the actual time of the commencement. The specified time of when the indemnity will start has not been stated in the act, in the Indian Contract Act. Therefore, there are certain judgments which are made with some courts, they are differing with one another. The specified time for notice, where notice has to be given to the indemnifier as per the terms of the indemnity, then the indemnity holder has to abide by it. If a specific time has been given, then the indemnity will commence as per the situation, the time that was given in the contract. Otherwise, it will be according to the decisions that are taken by the court. Okay, so this is the contract of indemnity. Then if we talk about the contract of guarantee, the contract of guarantee. So a person who gives the guarantee is called the surety. Again, three people are involved in here. Three people. Let's say two people, person A and person B are there. Right. Person A wants to take a loan. Person A wants to take a loan from person C. But this person is not sure whether A will repay the loan. They are having certain doubts. So what they can do, person A will provide a guarantee that if A does not repay, then I will pay it to you. Okay. So this is a form of guarantee. This is a form of guarantee that a contract between A and C is made on the guarantee of B that if A does not repay to C, then what will happen? B will pay the sum that was in the contract to C. So B is acting as the guarantor. the person that is providing the guarantee. Right? So it is a contract to perform the promise or discharge the liability of a third person in case this third person defaults in their payment. Again, the guarantee can be oral or written, but whether it will be a valid contract or not, it will depend upon various conditions. So the person who gives the guarantee is called the surety, and the person in respect of whose default the guarantee is being given is the principal debtor. The principal in respect of whose default the guarantee is being given. So here in this case, principal debtor is C. No, principal debtor is A. C will be the creditor. Right? A, B, C. Principal debtor is A. The person in respect of whose default the guarantee is being given, that is, if A defaults, then C will come into action, and B is the creditor or the beneficiary, the creditor. All right. So, however, again, it is very important to note here that when C provides the sum to B, the contract will not end here. C will also have the right to recover the amount from A from the principal debtor. Right? B, after he has paid the amount, C, after he has paid the amount, they can claim the same from A. So this is a unique feature of the contract of guarantee. So there are two separate agreements, each between the two parties. First was an express contract between the person standing as the guarantee, that is person C, and the person to whom the guarantee is being made, the creditor. Right? So between B and C. Second agreement is between the person who is being guaranteed and the surety, and this is an implied contract. All right, so there are more than one contracts or agreements that are entered to here. So this is the guarantee. Now under this guarantee, a term called consideration is given. Anything done or any promise made for the benefit of the principal debtor is sufficient consideration to the surety for giving the guarantee. So what consideration does the guarantor or the surety require for giving the guarantee? So anything done or any promise that was made for the benefit of the principal debtor, this will be the consideration to the surety for the guarantee. Like if B requests A to sell and deliver to him the goods on credit, and A agrees to do so, but on the condition that C will give guarantee for the payment of the price of goods. So C promises to guarantee the payment in consideration that A is going to deliver the good. And this will be a sufficient consideration for the C's promise. All right. Then if we talk about what is the liability of the surety. So the liability of the surety is coextensive. This is very important to remember. It is coextensive, existent, okay? It is coextensive to that of the principal debtor unless it is otherwise provided. That is, the surety is regarded as a favored debtor. Only if the principal debtor is unable to pay the debt, then the surety takes the place of the principal debtor. Otherwise not. If A defaults on the payment, only then C will act as the surety and make the payment. So they are acting as the secondary person. The secondary person. Thus, this relationship is coextensive. Right? Again, once the surety has been paid, it then the person will occupy the place of the original creditor. So it is coextensive. Understood what is the meaning of coextensive? That is, the principal debtor is only secondary. They will pay the same sum only if the surety is secondary. They will pay or they will make the payment only if the principal debtor makes the default. Otherwise not. Right? So this is there. Then what is the meaning of a continuing guarantee? A guarantee which extends to a series of transactions is called a continuing guarantee. This means that this type of guarantee is not limited to only one transaction but to many transactions. right? So let's say again Mr. A contracts with Mr. B, which is a shopkeeper, that they're going to allow Mrs. A to take whatever goods she needs from the shop. So this person, Mrs. E, they are going to continuously take goods from the shop. It is not going to be a single transaction. And the person A, who is in contract with Mr. B, they are going to keep the payment. They're going to keep making the payment, right? So it is of a continuing guarantee. It applies from time to time for the amount that is due and payable from the principal debtor to the creditor, right? This is done. Then what happens in the case of death of surety? Normally, when the surety dies, the guarantee ends from there. However, it is not true in all the cases. It depends upon the terms of contract in the intention of the parties. If in between of the contract, if in between the duration of the contract, the surety dies, normal conditions, what will happen in normal conditions, the guarantee will end. But if during the signing of the contract, making of the agreement, they had termed that no, it will be carried on or another person will be assigned the guarantee, so that would be a special case. But normally what will happen, at the death of the surety, the guarantee will end from that date. Then if there is a variance in the terms of the contract, variance means any change or modification. If any variance is made without the surety's consent in the terms of the contract between the principal debtor and the creditor, then it will discharge the surety as to the transactions that are subsequent. That is, if A, B, and C are there, the principal debtor and the creditor, they take certain decision and they change the terms and conditions without the knowledge of the surety or the person C, then the person C will be discharged. They no longer need to perform their duties after the changes have been made. All right. Then the discharge of the principal debtor. The surety is discharged by any contract between the creditor and the principal debtor by which the principal debtor is released, or by any act or omission of the creditor. Let's say this principal debtor makes the payment to the B, that is, they do not default. Then the principal debtor will be discharged and the surety will be discharged, right? This is very simple, this is very clear. So regarding, if there are more than one sureties, then the discharge of one surety, will it lead to the discharge of another surety also? That is not true. Okay, it does not, one person does not become free from the responsibilities because other person has also been discharged. The surety can also claim their dues from the principal debtor. We have already seen this. So there's a double contract, not just between the surety and the creditor, but also between the surety and the principal debtor. If there is any misrepresentation that is made by the creditor, then it will be invalid. If any guarantee is obtained by the means of misrepresentation made by the creditor, then it will be termed as invalid, right? Then co-sureties can exist for the same debt. Even revocation of the continuing guarantee can also be made, that it can be revoked by the surety as to the future transactions, but they will do so only by giving a notice to the creditor, right? They have to inform the creditor that I'm no longer going to perform the responsibility of the surety. All right. Yes. Next type of contract is the contract of bailment. So when we talk about bailment, what is the meaning of bailment? It means to deliver, right? Deliver, and in the legal sense it means handing over or the change in possession of the movable property from one person to another. So delivering a movable property or handing over a movable property from one person to another, that is known as bailment. Again we have the term bailer and bailee. Bailer and bailee, the person who is making the delivery of the goods is known as the bailer, and the person to whom the delivery is being made is the bailee. Again, word ending with or is the person who is performing the action, and double e is the person for whom. So, delivering the goods is the bailer, and the person receiving or to whom the goods are delivered is the bailee. Right? So, if a person already in possession of the goods of another contracts to hold them as a bailee, they thereby they are going to become the bailee when the goods are delivered by the way of bailment. So there are section 148 to section 170 of the Indian Contracts Act deals with the contract of bailment. Now, when we are talking about the goods, the movable property are being exchanged from one person to another, there are certain considerations that need to be kept in mind. There should be a contract. There should be a valid contract between the two parties to deliver the goods. It will express the time, the place, and how the delivery will take place. Then regarding the delivery of goods, again, all of these things. Then the delivery of possession as well, not just the good but also the control and intention, the possession will be transferred. What is the purpose? Then if in case there is a return of specific goods and there is no transfer of ownership. All right, so goods here have been defined. It includes every kind of movable property only. It excludes the money and actionable claims. So the bailment is the delivery of goods alone, right? Whenever we are talking about the involvement of money, then we will say it is a sale and not bailment, since ownership passes to the buyer. So only the goods are being exchanged here, right? So the bailer needs to take care that whatever goods they are providing, they should be of good condition, and they should be according to the sample that they have provided. Bailey should also take care when they are taking possession of the good. They need to make sure that they are not encumbering or they are not harming the good. Right? They have to make sure that they are not causing any damage to the good. Otherwise, the bailer can demand the bailee to pay the damage that is suffered. What if the bailer if the bailee mixes the goods of the bailer within own goods? Then again, the claim can be done. If the bailee, without the consent of the bailer, mixes the goods with his own goods, then what will happen? The bailee is bound to bear the expense of the damage that is arising from the mixture. Like if good quality socks are mixed with bad quality socks, then what will happen? The quality will go down. It will be a loss for the bailer. So that will be borne. Then duties of the bailee with regard to the goods we have already seen. We also have the bailee's lien, that if the bailee has rendered any service, if let's say there is an exchange of raw material, or let's say machine. A machine was given by the bailer A to the bailer B to use that machine and produce any textile or clothes. Now, the B person can keep lien of this machinery or the good until they receive the remuneration for the services that they have rendered. So, the bailee has the right to retain such goods until he receives the remuneration for the services that he has rendered. Alright, so this is the bailee's lien. Bailee's lien. Right, so bailment is the delivery of goods by one person to another for some purpose. When the purpose is accomplished, the goods are to be returned or otherwise disposed according to the contract that was signed. Bailment is not same as the sale, because sale is an intentional transfer of ownership, wherein bailment only the transfer of possession is made, or the custody, not the ownership. Right, so this is there in the contract of bailment. Next, we have the contract of pledge. Now, what is a pledge? What is a pledge? It is somewhat, we can say, a promise, And again, the bailer herein will be called the pawner and the bailee will be called the pawnee. Bailer and bailee. So let us see what is happening here in the pledge. So the bailment of goods is used as a security for payment of a debt or the performance of a promise. Then it will be known as a pledge. So as per section 172 of the Indian Contracts Act, the bailment of good is now used as a security for the payment of debt. So bailer will be called the pawner and bailee will be called the pawnee. So a contract in relation to the identified, let's say, goods to be delivered to the pledgee as a security. Then what is happening here? The actual delivery of possession is taken in place. The property pledged should be actually and constructively delivered to the pawnee. So these are the certain terms. So what will happen in a pledge if the pawner makes a default in the payment of the debt in respect of which the goods were pledged, then the pawnee may bring a suit against the pawner and then retain the goods pledged as a security, or he may sell the goods pledged after giving notice of sale to the pawner. So here the pawnee has the right that if the bailer or the pawner defaults, they are not making the payment. So the pawnee can do what? Either they can keep the possession of the goods that are pledged, or they can do what? They can sell the goods to recover the debt, right? So this is what will happen in a pledge. So if the proceeds of such sales are, let's say, less than the amount due, then the pawner is still liable to pay the balance. So if a question is asked in the examination, what happens if in a pledge the pawnee makes a sale but still amount is due? What will happen? Will the pawner or the bailer be liable? So yes, the pawner is still liable to pay the balance. If however the proceeds are greater than the amount, then the pawnee shall pay the surplus to the pawner. So both cases are there, right? So all contract pledge is a type of bailment which was brought out earlier, and now a pledge is created on the possession of the group, right? The pawnee can retain the goods pledged if the payment default has been made. So this is there. Then sometimes despite a charge of the pledge available to the creditor or bank, it allows the custody of the immovable property pledged remain with the debtor for a special purpose. But this does not violate the effectiveness of the pledge. These types of statements can be used in the case study where under circumstances the pledge further pledges the movable property. So if the pledgee who has already created a pledge and they are further pledging the movable property, then the pledge will be valid only to the extent of the interest of the pledgee, which is equivalent to the amount for which the property has been given to him as a security. If the security or if the property, it has a greater value but only a certain part of the value or certain amount has been given as security, only that amount can be used as creating a further pledge on the movable property, not on the whole property. So make sure that you understand these things. Case study questions, they're asked from module D, and these types of situations are given to you. Like what will happen if the pledgee decides to further pledge the movable property? Will they use the complete value of the property? No, only the extent of the interest of the pledgee which was equal to the property that was given to them. So this is the pledge by a pledgee. Pledge by a pledgee, right? Apart from that, this, when we discussed, this was the pledge without actual possession. All right. Okay. Next we have the contract of agency. Agency is, let's say, a third party. It is a third party. Again, Now, agent is working on behalf of the person. So, the contract of agency, it might stem from the need which arises sometimes for a person when they're employing another person to do an act for him or to represent him or her in dealing with the third person. So, this term agent and principal has been defined in section 182 of the Indian Contracts Act. In terms of this section, an agent is a person who is employed to do any act for another person or to represent another's in dealing with a third person. So the person for whom the act is done or who is being represented is known as the principal. So person A and person B. Person A is the principal and person B, let's say, is any other person with whom they have signed a contract. They have signed a contract. And person C is an agent. Now, this principal will employ this agent person C and tell them that you go deal with B with all the payments or application or anything. You will act on my behalf. Here, what is important to note is that no consideration is necessary to create an agency. No consideration. This person, agent, will be employed, let's say, in return in terms of money, but agent will not give anything in return to the principal. So consideration is not required. All right. Now here again, the principal should be competent to a contract. They should be of the majority age. They should not be of unsound mind, or they should not be otherwise um, debarred from the court to perform. If we are talking about the rules of agency, first rule of agency states that whatever a person can do personally can also be achieved through the agent. Obviously, there are some exceptions, but whatever this person A can do by herself or himself, this person, agent C, can also do on behalf of the principal. Now, there are two types of agents. Agents are on the basis of their authority and on the basis of the nature of work that is performed by them. So, on the basis of authority, we have a special agent for a particular act, they are being appointed. Or we can have a general agent who can do all the acts in respect of the principal, the line of business, the trade, or employment. We also have the universal agent, which has agent is one whose authority to act for the principal is unlimited, right? It is unlimited. Then the nature, it can be a mercantile or commercial agent, or even bank can act as agents, so bankers. And we have the non-mercantile agent. So there are certain duties and rights of the agent and the principal, like the agent has to carry out the work undertaken as per the directions given by the principal. They have to carry the work out rationally. They have to communicate with the principal if they face any difficulty. They should not take any independent decisions, or they should not, let's say, use their own accounts for transactions in place of the principal. The principal has duties like to indemnify the agent against all the consequences. All the acts are done in good faith, or indemnify of any injury that is caused by the principal's neglect. Again, they have the right, if they have employed an agent, they have the right that their all the actions or acts that are mentioned, they will be performed by, or the duties will be performed by the agent. All right. Next, we move on to the, we have seen the different types of contracts: agency, contract, then guarantee, indemnity. Now we move on to the meaning and essentials of a contract of sale. Earlier we were discussing about bailment, lien, and other things. Now, what is a contract of sale? This is given under the Sale of Goods Act. So the contract of sale can be absolute or it can be conditional. In the absolute contract of sale, there are no conditions to be fulfilled by the seller or the buyer for the sale and purchase of the goods. There are no conditions. It is absolute. The sale will happen in any way. The buying and selling will happen. It does not require any condition. On the other hand, in the conditional sale, what is happening? The parties to the contract, they agree that the sale of goods shall be regarded final only on the fulfillment of certain conditions, either before or after the conclusion of the contract of sale. So the conditional contracts, they set certain conditions that only if this condition happens, the sale will take place. The absolute, on the other hand, says whatever happens, it doesn't matter, the sale will take place. So, goods here, we are talking about the stocks and shares, agricultural crops, or anything. Buyer will be the person who agrees to buy, seller will be the person who agrees to sell, price will be the money consideration, delivery will be the transfer of possession, document to deeds, the document of title to goods will include the dock warrant or the warehouse's keeper certificate, any railway receipt, anything at all. Future goods means the goods to be manufactured or produced after making the contract of sale. Mercantile agent will be the authority either to sell goods or consign the goods. Now, when we are talking about the sale of goods, the contract of sale of goods, then the property in the goods is transferred from the seller to the buyer. There is the bilateral contract where two persons are there, buyer and seller. There is the money consideration wherein the sale of goods must be money, the consideration must be money. Movable property for the and the immovable property is there, right? So immediate delivery can be made for the delivery of payment by installment, or postponement of delivery of payment also is there. Now there is a difference between the sale and an agreement to sale. Sale and agreement to sell. Sale is the contract of sale. The buyer buys the product from the seller at the same time. The title of the good is transferred immediately. So, payment, as the payment is made, immediately the good is transferred. There are no conditions to fulfill the sale. Sales are like the completed contract. The buyer can recover the goods in the case when the seller sells the goods to another person. If the seller and buyer, they came into contract, but the seller has sold off their good to another person, not to this person. If I am the buyer and I agreed with another person, the seller, that they will deliver to me such and such unit on such and such date, but before that they have given that goods to another person, then I can recover the goods. The buyer is responsible for the loss. The buyer does not have the right to sue for the damages against the seller. However, in the agreement to sell, the goods are not immediately transferred. It remains on the seller itself. The title of the goods is transferred on the future. So, what is happening here? When we are entering the agreement, the title of the goods or the goods will not be immediately transferred. It will be given to me in the future. And only by fulfilling the conditions, the title of the goods is transferred, not before that. So agreement to sell is a nature of the contract which has to be complete. When the seller sells the product to other party, the buyer cannot recover the goods, but he can claim for the damages. Here, the seller is responsible for the loss. Under the sale, buyer is responsible for the loss, but under the agreement to sell, the seller is responsible. And the seller cannot sue the price, but he can sue for the damages. So these are the differences. The risk in goods is with the buyer in the case of sale, and the risk here, it still lies with the seller, and it will only pass on to the buyer after the agreement to sell becomes a sale. So this is the difference between the absolute sale and an agreement to sell. Next, we talk about the conditions and warranties. The conditions and warranties. Every contract has certain stipulations. These are given under the Sale of Goods Act, Section 12. All right. So, what is the difference between a condition and a warranty? If the stipulation agreed to between the parties is essential to maintain the purpose of the contract, and it is of the nature that if the stipulation is breached, then the party to the agreement would have the right to treat the contract as repudiated. Then it is called a condition. So condition is a stipulation wherein which is very necessary for the main purpose of the contract. And if the condition is violated, it is not complied with, then what will happen? The agreement would have the right to treat it as repudiated. The party will treat the agreement to have been cancelled or repudiated. But it is not the case of warranty. Warranty is a stipulation collateral to the main purpose. So the main purpose that is served by the condition, a collateral type is provided by the warranty. So the breach of such stipulation gives rise to only the claims for damages. A contract cannot be termed as repudiated if the breach of warranty is there. The parties cannot reject the good and treat the contract as repudiated if there is a non-compliance of warranty. Alright, so this is the difference between a condition and a warranty. Now there are implied conditions and warranty. What is the difference between implied conditions and implied warranties? In the implied condition, condition as to the title is there. In the implied warranty, warranty of quiet possession is there. Implied concession is the sale by description as to the quality or fitness, mercantability, custom, sale by sample, condition as to the wholesomeness. What is implied? That the quality of the good or the property is of good. It is fit and proper. This is the implied condition. It goes unsaid. The buyer will assume that the good that is to be provided to me, it will be of a proper quality. It will not be damaged, it will not be hampered. Implied warranty, on the other hand, it is the warranty of freedom from encumbrances, the quality or fitness by usage or trade, to disclose the dangerous natures of the goods. Alright, so the implied condition, the warranties and conditions, they can be either expressed or implied. In the implied condition, the seller has the right to sell the goods, or they will have the right to sell the goods at the time when the ownership is to be passed to the buyer. Right, then there's the sale of description, that the goods they correspond with the description. Sale by sample, again the bulk should be same, it should correspond with the sample that is provided in terms of the quality. Right, it should be free from any defect. Sale should be sample, it should be same as given in the description. Quiet possession is an implied warranty, that the buyer shall have and enjoy the quiet possession of the goods. So here you need to remember this, what all is included in the implied condition and what all is included in the implied warranty. All right, so the goods should be free from the any charge or encumbrance. This is again an implied warranty. The quality of the fitness or goods, again there is no implied warranty or condition to the quality of the fitness of the good. Right? Then yes, one very important thing is the caveat emptor. The caveat emptor. What is the meaning? It means, it basically is a warning. It tells the buyer to be aware. So according to the doctrine of caveat emptor, the person who buys the goods must be aware. They should keep their eyes open, their mind active. They should be cautious when buying the goods. So they must examine the goods thoroughly. If later on, when the purchase has been completed, when the delivery of goods has been done, and then the buyer is saying that the goods do not serve the purpose, then it will be dependent on their own judgment, and they cannot blame the seller for selling him the goods. So there is no implied warranty or condition as to the quality or fitness of the good. So caveat emptor, we will remember this by saying beware buyer. We are telling the buyer to beware. All right, okay. Next, when we talk about the unpaid seller, unpaid seller, the seller has delivered the good but whole price has not been paid or tendered, or when the payment for good is received in the form of check and the check is dishonored due to financial or other reasons, then this term will be given as the unpaid seller. So, what are the rights of the unpaid seller against the goods and the buyer? Against the goods, where the property in the goods has passed to the buyer, so they have the right to lien, they have the right to stop the transit, and they have the right to resale. This is where the property in goods has passed to the buyer. Second, where the property in goods has not passed to the buyer, they can withhold the delivery, lien, stoppage in transit, or resale. Right? Then the unpaid seller also has rights against the buyer. They can suit for the price, they can file a suit for the damages, also they can file a suit for the interest. Very easy, right? So against the goods, a lien on the goods for the price while he is in the possession of them, or in case of insolvency, they can stop the goods in transit, or they can have the right to resale the goods to another person, right? So the goods, if they have been sold without any stipulation, they can keep the lien. Okay, so this is there. These are the unpaid sellers, right? I think these are very simple, very clear. We don't need to go into detail. Next, we move on to the act, the Partnership Act. Okay. So the Partnership Act of 1932. I hope you all are not tired. We just need to do this revision, and we'll be done with our preparation for tomorrow. So this is the last final leap, the last final step towards our exam preparation. So when we talk about partnerships, it is a relation between persons who have agreed to share the profits of a business that is carried on by all by or by some of them that are acting on their behalf. So when they are coming into a partnership with one another, they are individually called partners, and collectively they will be called a firm, and this firm will be under a common name. So these partners, they are mutually coming together to share the profits, to share the workings, and we are terming it as a partnership, right? So partnership is not a separate legal entity like a company that is formed. We will see this why. So the partnership, it can be a contract between the partners that may be oral or written. Then the partnership must be formed to carry on some form of, okay, yes. So to share the profit, to earn return of the business, there must be a mutual relation of agency between the parties. These are the various characteristics of a partnership. So there should be an agreement between two or more persons. Then the maximum number of partners that can be there, it is defined by the Companies Act of 2013. A partnership firm should not have more than 100 partners, and the limit can be increased as per given by central government. But under the Companies Act, maximum number within the limit of 100 is given. If it exceeds 100, the partnership becomes illegal, right? Then if we talk about the agreement, again it can be oral or written, that we just stated. Regarding the business, so it is imperative that all the partners, they carry out the business as given in the partnership, and it should be legal. Then profits will be shared with the partners, no partner shall be deprived of the profit. Now the main important topic from this chapter is the types of partnership. The Partnership at Will is given under Section 7, where no provision is made by a contract between the partners for the duration of their partnership or for the determination of the partnership. It is known as a partnership at will. On their own will, on their own decision, they have agreed to come together, and they have not decided the duration. This partnership will continue till they decide to dissolve. So the partnership at will can be dissolved by any partner by giving notice in writing to all the other partners, of his intention to dissolve the firm. Alright, so no duration is mentioned. At will, the partnership firm will exist, or it will cease to exist, or it will dissolve. Then we have partnership for a fixed period, where two or more persons they enter into a partnership agreement for a fixed period of time. Then it is known as a partnership of fixed period. So when this period comes, when the period has been fulfilled, it will automatically come to an end. However, if the partners they decide that they still want to carry on with their business after the fixed period, they can also do so. And when they carry on, the mutual rights and the duties they will remain unaffected as they were before the continuing of the partnership, or before the term had finished. So it will automatically be transformed into a partnership at will. All of these things are case study material. The case study might ask you that a firm XYZ came into a partnership for a fixed period for, let's say, 10 years. After 10 years, the partners they decided that they wanted to increase, or they wanted to continue with the partnership. How will the terms and conditions, or how will the rights and duties be affected? So the duties will remain absolutely unaffected, and the partnership is automatically transformed into a partnership at will. Then the third type of partnership is a particular partnership. Herein, the partnership is entered into for completing a particular job or assignment that is taken up. So a particular goal is decided, and once the goal gets over, the partnership or the firm will be dissolved. Right? So hence a person may become a partner with another person for a particular adventure or for a particular undertaking only. So this is a particular partnership. Three types of partnerships are there. We also have the limited liability partnership, which are contained in the Limited Liability Partnership Act and the Limited Liability Rules. Basically, LLP is a separate legal entity that is liable to the full extent of its assets. The liability of the partners is limited. Right? Why it is called a limited liability? Because the partner's liability is limited. We will see about this in detail in the further chapters. So LLP is a body corporate and a legal entity. The mutual rights and duties of the partners they will be governed by the agreement. No partner is liable on account of the independent and unauthorized actions of other partners. Then a firm, a private company, or unlisted private company, they can be converted into the LLP following the terms and conditions and provisions. All of these things are there. We have a separate chapter which is a limited liability partnership where we will discuss this in detail. Okay, yes. So the mutual rights duties of the partners they may be determined by the contract between the partners. The rules for conduct by the partners are stated in the partnership form. Then, regarding the rights and duties of the partners, if there is a change in the partner of the firm, the mutual rights and duties of the partners reconstituted will remain the same as they were immediately before the change. So, it does not matter if the terms and conditions change or the partners change, the duties and obligations will remain the same. Also, every partner is liable jointly with all the other partners, and also especially for the acts that are done by them while they are a partner. If, however, they are doing any act outside of the purview of the firm or the LLP, then all the members will not be jointly liable. Only for the actions that are regarding the particular business will the liability be shared by all the partners. The misapplication by a partner is dealt in section 27 of the Indian Partnership Act of 1932. There are various doctrines, like the doctrine of holding out, which is given in section 28, that anyone who by words spoken or written or by conduct represents himself or herself knowingly to be a partner, that they are represented to be a partner in the firm, they are liable as a partner in that firm, or any such representation given credit to the firm, whether the firm representing himself or represented to the partner does not know the representation has reached the person so giving credit. A long definition is given, the doctrine of holding out. Basically, the meaning of doctrine of holding out is very simple. Holding out means that when a person who was not at all a partner in the firm, they are they are doing what, they are representing themselves to be a partner in the firm, so they are doing what, they are somewhat misleading. So such stranger will be individually liable and personal for the debts of the firm as he was a partner if the firm on the principle of holding out. So this is the principle of holding out, right? They are representing themselves as to be the partner of the firm, either knowingly they are representing themselves, they are inducing others to give credit to the firm, then is known as a partner, that is holding out. They are themselves categorizing themselves. All right. Then we have the section 39 of the act, which talks about the dissolution of a partnership between the partners. Dissolution. Dissolution can be occurred in a partnership firm if all the partners except one are adjudicated insolvent, and by the happening of any event which makes it unlawful for the business itself to be carried on, or the event makes the business unlawful. So if the partners are insolvent, declared insolvent, or if any of or the business or the firm has engaged itself into an unlawful business. However, if the firm, let's say firm ABC, was involved in four different businesses, and this only one business has been declared as unlawful, then the firm need not dissolve the other business as well. This has been given, right? This has been given regarding the dissolution of the firm. So compulsory dissolution, we have stated if all the partners are adjudicated insolvent or any unlawful activity. But also what can happen, the dissolution can be taken place by the court if the partner has become of unsound mind, or the partner is permanently incapable of performing the duties, or the partner they commit a breach of the agreement. Now what is the liability for the acts of partners done after the resolution? So any or all of the partners of the firm, they must give a public notice that the firm is being dissolved. So this is because even after the dissolution of the firm, the partners continue to be liable to the third parties until such public notice is given. So if you dissolve the firm but you have not given a notice, a public notice, then you will still remain liable to the third party. So it is very important that you make a public notice. Right. Now, regarding the registration, is it necessary for a partnership deed to register? No. A company is compulsorily required to be incorporated and registered with the registrar of companies, but the partners, they may or may not enter into a partnership deed, and they may decide to have a oral partnership. So they will not get themselves registered. What will be the effect of this non-registration? If the Partnership Act casts certain disabilities, they are allowed to continue without registration, but they will face certain disabilities that you need not study here. You just need to remember that these disabilities are given in section 69 of the Act. Firms that are not registered with the registrar of partnership firm, they face certain disabilities which are given in section 69, and because of that the partnership firms, they decide to register to avoid future hassles and complexities. So it won't create any difference. No suit to enforce a right will be created, no suit to enforce a right from a contract shall be instituted, and all of these things are there, right? Next, we have the Companies Act. The Companies Act 1956 or 2013. So Section 3 of the Companies Act 1956 defined a company as a company that was formed and registered under this act or an existing company. So before the act came into force, if the company was existing, the act stipulated that this existing company will also have to get registered with the Companies Act. So what is company? Company is an artificial illegal person which is created by the law and can be dissolved by the law alone. It is an artificial legal person. Registration is made under the Companies Act of 2013. What is the meaning of artificial legal person? They enjoy many rights of a natural person, but it person is invisible, intangible, and they exist only in the eyes of the law. So the company may enter into a contract in its own name, it can acquire and dispose of property, and they can also be fined under the provisions for the violation of a law. Now we have different types of companies. We have the companies under the Companies Act 2013 as the one person company, private limited company, public limited, and Section 8 company. Based on size, we have the micro, small, and medium company. Based on liability, limited by shares, limited by guarantee, and unlimited company. Based on control, holding company and subsidiary company. Based on listing, it can be a either listed company or a unlisted company. Now, we need not go into detail, we need not understand each and every term, each and every type of these companies. Only the types of companies that exist is enough for the examination. Now, one very important topic of Companies Act is regarding the Memorandum of Association and the Article of Association. What is the difference between these two? First, tell me what is more important or what is of more parameter, whether it is the memorandum or whether it is the articles of association. Like if a dispute occurs, then between the MOA and AOA, then conditions given under which of the following will be taken as final. Tell me this. Now let us, so memorandum of association is actually the first step which is taken in the formation of a company, the preparation of memorandum of association. So this will include the name of the company, which is the name clause, the state in which the registered office is there, which is a registered office clause, then objective clause, which talks about what is the objective, what is the purpose for which it is being incorporated, it is the objective cause. Then liability clause, whether the company is a limited liability. Then the capital clause, that what is a share capital, and the association of subscription clause. So there are 6 clauses under the MOA that have to be stated. These 6 clauses are name, registered office, objective, liability, capital, and association of subscription. So all of this information has to be provided. The conditions upon which the company is incorporated, if it is subordinate to the act, if it is filed by all the persons of the company, the MOA cannot be easily altered, and it defines the relations between the companies, outsiders, creditors, and buyers. Article of association, on the other hand, these are the internal regulations of the body. So MOA, again we can state it as the external. Why? Because it is governing the relationship between the company and the outsiders. Internal regulations, on the other hand, come under the articles of association. It is subordinate to the act. So here it is clearly mentioned that the AOA is subordinate to the Act, Companies Act, as well as the Memorandum of Association. So the Memorandum of Association has greater power than the Articles of Association. Here the public companies limited by the share need not file the AOA. They can be easily altered, and it governs the internal relationship between the company and the members. Sorry. All right. Now there are certain doctrines that are stated under the Companies Act. These doctrines are again very important. We have the doctrine of ultra vires, the doctrine of constructive notice, and the indoor management. All right. So the doctrine of ultra vires lays down that a company cannot carry on the objects not permitted by its memorandum of association. Basically, it tells the extent that is permitted by the act or permitted by the memorandum of association. So when a company exercises its power to promote or realize any of its objectives, they have to be stated in the MOA. They have to be within the powers of the company, right? They cannot move outside of that. So this is ultra wire, the doctrine of ultra wire. All right. So an ultra wire transaction, we will say it can be, the term that we used was void ab initio, wherein the minor cannot enter into a partnership, right? Then no company can be held liable for the obligations that are arising out of such a contract. That is the void ab initio. Okay. So I think that is that the ultravires requires that the company cannot carry on the objects not permitted in the memorandum of association. Okay. Then we have the constructive notice, the doctrine of constructive notice, that he who deals with the company is deemed to have notice of the public documents. Let's say the company, they are entering into an agreement with a person or another company, and they are giving them out a document stating all the terms and conditions, workings, objectives, and so on. So here the company will assume that I have given out this document, and this person, the other person, let's say person B, has read them, and then only they have given their consent, right? So the company will assume that every outsider have read the memorandum of association and the article of association. This is the doctrine of constructive notice. But when the person, the doctrine, it is a negative nature, because it is not going to stop a person from arguing that they had no notice of the content of the public document. What if they argue that when you had given me the public document, you had written some other things, but you have changed it? So it is a negative nature. So in companies law, the doctrine of constructive notice is a doctrine where all the persons that are dealing with the company are deemed to have knowledge of the company's AOA and MOA. All right. This is the doctrine of constructive notice, that we have given you a constructive notice. Now it is your responsibility that you should know all the workings of the company. But an exception to this doctrine of constructive notice is the doctrine of indoor management. So this is an exception. It lays down that the outsiders are not required to see the compliance of internal regulations of the company. Right? It protects the doctrine of constructive notice. It seeks to protect the company against the outsiders. The company is believing that the outsiders have read my terms and conditions, they have read my MOA and AOA. But the indoor management, it seeks to protect the outsiders against the company. So if a question comes, make sure that you mark it right. Which of the following doctrines aims to protect the company against the outsiders? It is the constructive notice. And which of the following aims to protect the outsiders against the company? It is the indoor management. Right? So a person who deals with the company, it is deemed to have read and understood the registered public document. But this is an internal person. Any outside person cannot be expected to know everything about the person, about the company. So the indoor management should be known. The indoor people, internal people involved in the company, they will know about everything, but the outsiders, the customers, they will not. This is the doctrine of indoor management. All right, this is there. Then if we talk about the membership of a company, So how can a person become a member of the company? It is defined under section 2, subclause 55 of the Companies Act 2013 that any person competent to a contract can be a member of a company. That is, they are of the majority age, and they're not of unsound mind, then they can be member of the company. How can they do so? They can become a member of the company by subscribing to the memorandum of association, or they can gain membership by allotment of shares, by the transfer of shares, transmission of shares, membership by acquiescence, joint membership, or beneficial owner in the records of depository. So member is a person who is a subscriber to the memorandum of the company. They've agreed to become the member, right? So by subscribing to the MOA, they're on the registration of the company, they can become the members. Then for the allotment of share, if they take shares, if they are allotted the shares, then they can become members. If a person buys shares of the company in the open market and then applies to the company to register him as a member, then also they can do so. So that is a transfer of shares. Transmission of share, if the member has not made a nomination for the shares, then the survivor of the joint holder. So what they are doing, they are making a transmission. The joint holder or the legal representatives, they will have the right to become the to be registered themselves as members of the company. So this is the transmission of shares. Another way is membership by acquiescence. So a person is deemed to become a member of the company if he or she allows his name to be put in the register of the members. Simply, they are not denying their membership, they are giving agreement. They can write the name in the registers. All right. Joint membership, when two or more persons they hold shares in the company jointly in their joint names, then there it is known as a joint membership. Then beneficial owner in the records of depository, every person that is holding shares of the company and whose name is entered as a beneficial owner shall be deemed to be a member of the concerned company. So these are the various ways through which membership can be gained. So any person who is competent to a contract, then company as a member, partnership firm, registered society, non-residents, all of these can be members of the company, right? But fictitious persons who make a fictitious name, or they induce the company to allot the shares to another person's names, these will not be allowed. Or a limited liability partnership can become, or an insolvent person cannot become. They can become as long as they are registered, their names are on the registered members list, and union members, right? When can the membership in a company be taken away? If the member transfers his shares to another person, if the member's shares are forfeited by the company, if the shares are sold pursuant to a decree of court, if the company is being wound up, right? So registration can be done under the Companies Act 2013. Every company shall keep and maintain the register of members, the register of debenture holders, register of any other securities. All of these things are there regarding the registration. Next, we move on to the prospectus. Now, what is a prospectus? Prospectus is defined under Section 2 of the Companies Act of 2013. It is a document described or issued as a prospectus. It includes a red herring prospectus under Section 32 or shelf prospectus under Section 31. These sections are important. Section 31 talks about the shelf prospectus, and section 32 talks about the red herring prospectus. The difference between these two, again very simple, you have studied about this earlier also. What is the difference between a red herring and a shelf prospectus? Before that, right, so when any company, they are inviting the public, they are giving out offers for public subscription or purchase of securities of a body corporate, then they have to give out a prospectus to the public. In this prospectus or in this document, they will give the details related to the types of securities that they're bringing to the market, the date and time, the price, and any other relevant information. So the red herring prospectus means a prospectus which does not include the complete particulars of the quantum or the price of the securities. Red herring, only the relevant. It will not include all the information. On the other hand, shelf prospectus means in which the securities or the class of securities included are issued for subscription in one or more issues over a certain period without the issue of a further prospect. So it is, we'll remember this, that a prospectus is created and it is kept in the shelf. It will continue. It will continue for one or more issue subscription. It is issued for one subscription and it will same continue for other subscriptions as well over a certain period, and there's no need to issue a further prospectus. So the red herring, wherein complete particulars are not given, and shelf, which will continue for a certain period. All right. So if a person, let's say, buys the securities or subscribes to the shares and later on finds out that the information that was given was misrepresented or wrong information was given. So a person who has been induced to subscribe for the shares or debentures on the faith of a statement in the prospectus which is untrue, they have twofold remedy. They have a remedy against the company as well as the remedy against the promoters and experts who were responsible for the issue of the prospectus, right? And this liability can be criminal or civil. So when we are talking about the compliance, so the time of the issue of prospectus, the content, the date of publication, the signature of every director, the application form with the prospectus has to be provided to the underwriters and the existing shareholders or the debenture holders. Then the statement by expert in the prospectus, the registration of the prospectus, these are related to the compliance. However, if there is any misstatements that are made in the prospectus, then the remedies against the company might include the rescind of the contract, or the person can claim damages from the company, whether the statement is fraudulent or an innocent one, right? Criminal liability can also be implied if there was a fraudulent activity and that was willful. So certain matters and reports must be stated in the prospectus. If such information is not there or if that information is untrue, then the director or any other person that is responsible for the issue of such prospectus will be punished with fine. This is given under the criminal liability and civil liability, right? So the prospectus information that is to be provided under the prospectus and it is issued and circulated, it has to be made sure that no statement is untrue or misleading, or any context is provided, any exclusion or omission is made, then only the prospectus should be made public. All right. Okay. Next, when we discuss about the Limited Liability Partnership Act, the Limited Liability Partnership Act of 2008. We have already defined a limited liability partnership, a company where the partners are limited, their liability is limited. The definition of various terms like the what is the appellate tribunal under the Limited Liability Partnership Act. It means the National Company Law Appellate Tribunal, which is constituted under section 410 of the Companies Act of 2013. So the appellate tribunal wherein the appeals can be made is the National Company Law Appellate Tribunal. When we talk about the body corporate, so it means a company which is defined under the section 2 of the Companies Act 2013, It will include a limited liability partnership registered in the Act, or the limited liability partnership incorporated outside India, and the company incorporated outside India. So, three things are included in the definition of body corporate. Basically, LLP registered under the Act, or LLP incorporated outside India, and a company that is incorporated outside India. So these three entities are termed as body corporate under the Companies Act. Now, in a limited liability partnership, there are partners including a mandatory designated partner whose roles have been described in the section 5 to 7 of the Act, and the documents that are necessary are given in the section 11 of the statute. Right? So designated partner, what is the meaning of designated partner? What is the meaning of entity? Then what is the limited liability partnership agreement? It is any agreement between the partners of the uh, LLP, or between the LLP and the partners, which are going to determine the mutual rights and duties of the partners in relation to the LLP. Right? So all of these definitions are given under the Act. So body corporate, the LLP is a body corporate which is incorporated under the Act, and it is a legal entity separate from that of its partners. Then the LLP shall have perpetual succession, continuous succession. Any chance in the partners, any change in the partners of the liability shall not affect the existence, right, or liabilities of the LLP, that we have discussed earlier also. Right? Then, yes, we talked about the term designated partner. So, what is the meaning of this partner or designated partner? What is the meaning? Partner, if any person wants to become a partner of the LLP, then they cannot be a partner. Let's see the condition where they cannot be a partner. Same conditions are there if they are an undischarged insolvent, or they are of unsound mind as declared by the court, or they are insolvent, declared insolvent, or their application is pending. Right? These cannot be partners. Other than that, every limited liability partnership shall have at least two partners. Very important, very important. Keep this in mind. Every LLP must have at least two partners, and if at any time the partnership is reduced to one and the LLP carries out their business for more than 6 months, then the only partner that is left will now become, they will carry on the business alone. Right? So the only person that is left, who is the only partner of the LLP during the time that is so carries on the business, after those 6 months, and they have the knowledge of the fact that they are carrying out the business, they're liable for the personal obligations of the LLP. All right, so this time period is what? 6 months. 6 months. Time period is given under which the person can operate LLP individually. Then, if we talk about the designated partners, again, every LLP shall have at least two designated partners. Apart from these two designated partners, these are the individuals, and at least one of them should be a resident of India. At least one of them should be a resident of India. I'm writing this down, so make sure that you keep in mind. Two partners, two designated partners, at least one of them should be a resident in India. Now, if in case the LLP in which all the partners are body corporate, or in which one or more partners are individuals and body corporate, then what will happen? The corporate will work as the designated partners. The nominees of such bodies corporate shall act as the designated partner. So nominees clause is also there. The nominees will act as the designated partner. So, what will be the liability of the designated partner? If the person leaves, what will be the liability? So this designated partner will be responsible for doing all of the acts, all the matters, and the things that are required to be done by the LLP in respect of the compliance of the provision, and also they will be liable to all the penalties. So if a case study type question comes that the let's say Mr. A was a designated partner in the LLP XYZ, right? And one person leaves or two-person leaves, so what will be the responsibility? Options are given. Mr. A will be responsible for doing all the acts. Mr. A will be liable to all the penalties, so you will mark yes both 1 and 2. The designated partners will be liable and they will be responsible for performing all the acts like filing of any document, filing of return, any statement, report pursuant to the provisions. These responsibilities will come under the designated partners, right? Then when can we say cessation of the partnership will take place? We have already said if a person ceases to be a partner of the LLP, a person shall cease to be a partner of the LLP when on the death or dissolution of the LLP, if they are declared to be of unsound mind or incompetent, or they are adjudged as insolvent or they are declared as insolvent, right? Then so the person of a LLP ceases to be a partner until otherwise provided in the LLP. Amount equal to the capital contribution they're entitled to receive. Then they're also entitled to receive the right and share in the accumulated profits of the company. The former partner, they're entitled to the share in consequence of the death or insolvency as well. Right? So these are certain things. Now, what is important is when will the partnership firm be converted into a private company? When this conversion will take place? So, conversion of firm into a limited liability firm. A firm may convert into a LLP in accordance with the provisions of the second schedule. But conversion from private company to the LLP is given in section 55. Section 55 says conversion from firm to LLP. Section 56 says conversion from private company to LLP. And Section 57 says conversion from unlisted public company to LLP. So these sections you need to remember: 55, 56 and 57. A firm can convert, a private company can convert, and a unlisted private company can also convert into a limited liability partnership. All right, this is there. Then again, these conversions will have to be registered. The registration and effect of conversion should be known. I think that is enough, right? Okay. Next act is the Transfer of Property Act of 1882. The Transfer of Property Act of 1882. It means an act by which the living person they conveys the property in present or in future to another person, to one person or another person, to himself or one or more other persons. This comes under the Transfer of Property Act. We are transferring the property to another person. Herein we have the sale of immovable property, which is the sale of immovable property or mortgage. Mortgage. We have studied about mortgage in the previous chapters as well, but we will see in detail. So a sale of transfer of property in exchange for a price paid or promised, or part paid and part promised, will be considered as the sale of immovable property. So the sale of tangible immovable property for the consideration exceeding rupees 100 can be made only by a registered instrument, right? Now we move on to the important part, which is the mortgage. A mortgage is the transfer of an interest in the specific immovable property to secure the payment of the money that is given by a way of loan, or to secure the performance of an engagement which may give rise to a liability, right? So every person that is competent to a contract and entitled to a transferable property, they can authorize the transferable property. They can enter into the contract, or they can make the transfer. So the mortgager can be an absolute owner of the property. He can be one or more of the one of the two or more co-owners. They can be a karta of the Hindu undivided family, guardian of the minor's property, executor, administrator. Basically, what we are doing, we are making a transfer of interest in the specific immovable property. Now we will see the different types of mortgage. We have a simple mortgage, where without delivering the possession of the mortgage property, the mortgager binds himself personally to pay the mortgage money and agrees expressly or impliedly that the event of the failing to pay according to the contract, the mortgager shall have the right to cause. So the mortgager and the mortgagee. Mortgager is the owner of the property. They are signing this contract with the mortgagee that if they do not pay, then what the mortgagee can do, they will have the right that the mortgage property can be sold and the proceeds of the sale can be applied in the payment of the mortgage money. And this is known as a simple mortgage. A simple mortgage. So the mortgager does not deliver the possession of the mortgage property to the mortgagee. Then the mortgager binds himself personally to pay the mortgage money. And the mortgager agrees that if she or he fails to pay according to the contract, then only the mortgagee shall have the right to get the property sold and recover their dues. This is the case of the simple mortgage. Now, if we talk about the mortgage by conditional sale, where the mortgager ostensibly sells the mortgage property. So, the condition is given. What is the condition? On condition that on default of payment of the mortgage money on a certain date, the sale shall become absolute. So, a date is mentioned in the contract that if you do not make the payment, that I will make the sale. So condition is that if the default is done, then the mortgage will become absolute. Second condition, on such payment being made, the sale shall become void. If the payment is made, then I will not make the sale. And if the payment is made by the buyer, then the buyer shall transfer the property to the seller. Alright, so these are the three conditions wherein mortgage sale works. Right? Then so the mortgager, this sells the mortgaged property to the mortgagee. The condition that the sale will be default only when the default of payment is done, then it will become absolute, right? On on such payment that is being made, then the sale shall become void. Then we have the usufructuary mortgage. When the mortgager delivers possession or expressly or by implication binds himself to deliver possession of the mortgaged property and authorizes him to retain such possession until the payment of the mortgage money is done and to receive the rents and profits occurring to the property. So what the mortgager is doing now, he is handing over, they are giving the possession of the property, and if any rent is generated on the property, then they are claiming that rent or profit. So to appropriate the same in lieu of the interest of or the partly in payment of the mortgage money, this usufructuary mortgage can come into force. So the mortgager delivers possession of the mortgaged property. The mortgager authorizes the mortgagee to retain such possession until payment of the mortgage money is done, to receive the rents and profits that are arising from the property, to appropriate the same towards the payment of interest or mortgage money or both. All right, clear? So the main point here, if the question will be asked in which of the following types of mortgage, the mortgager retains the right of the rent and profits that are occurred on the property. So it is the usufructuary mortgage. Then we have the English mortgage, where again the mortgager binds himself to repay the mortgage money on a certain date and transfer the mortgaged property absolutely to the mortgagee, but subject to a provision that he will retransfer it to the mortgager upon the payment of the mortgage money as agreed. So if the mortgager makes the payment, he does not default, then the property will be returned or retransferred to the mortgager. Then we have the mortgage by deposit of title deeds or equitable mortgage, where a person in any of the following towns. Remember these towns: Calcutta, Madras, and Bombay, and any other town which the state government concerned may by notification provide. Then any person in these towns that delivers to a creditor or his agent documents of title to the immovable property with intent to create a security thereon, then the transaction is known as a mortgage by the deposit of title deeds. So only the title deeds are being provided, first condition. Second, they can do them by self or by the agent. And third, these are in the given towns of Calcutta, Madras, and Bombay. Right? So it is not necessary that the person is physically present. Right? It is not necessary that they are physically present. They are only making the transfer of the title deeds. And then we have the anomalous mortgage, a mortgage which is not of any of the categories that we just discussed and is generally a combination of two types of mortgages. That is the anomalous mortgage. But one question that might confuse this is that two types of mortgage combination can be used, excluding the mortgage by deposit of title deeds. So the anomalous mortgage can be created by combining two of the types of mortgages, but they cannot combine the mortgage by the deposit of title deeds. Very important. All right. So that is there. Then what is the meaning of actionable claim? Actionable claim means a claim to any debt other than the debt that is secured by the mortgage, hypothecation, or pledge, or to any beneficial interest in the movable property, not in possession either actual or constructive, which the civil courts recognize as given reliefs, whether such debt or beneficial interest be existing. So this is the actionable claim. The actionable claim. So the transfer of actionable claim, whether with or without consideration, it can be done only by the execution of the instrument in writing that is signed by the transferor. That is the actionable claim. The action will be taken only if the execution of the instrument is signed by the transferor. There is, however, no mandatory requirement of giving notice to the debtor. The transferee of the actionable claim can also sue the debtor in his own name without obtaining the transferor's consent. So all of these things are there. Right. Next, we have the Right to Information Act 2005. The Right to Information Act 2005, with the intent to provide for setting out the practical regime to give out the correct information to promote transparency and accountability in the working of every public authority. So the consumers, the citizens of India, they have the right to ask for information regarding any public authority. So in terms of the amendment that was made to the Act with effect from 31st 10 2019, It extends to the whole of India. So any place in India, the person can file an application and ask for the information. Right? So the provisions of the act relating to the obligations of public authority, designation of the public information officers and assistance public information officers, constitution of the certain information, central information commission, state information commission, all of these things are there, right? All of these things were there. In the amendment, uh, the extension was made to the whole of India, but the changes, these came out on 15th June 2005. All right. So certain definitions or applicability, if we see, so the appropriate government has to be understood as the definition of the public authority. Public authority can be the central government or the state government or any lower government in the state, union territory, right? Then the Central Information Commission, which is constituted by the central government under Section 2B. Then the Central Public Information Officer, and it also includes the Central Assistant Public Information Officer. These are given in the section 2. Why I have given it here? Because section 2 is important. Appropriate government, Central Information Commission and Central Public Information Officers. Now, right to information, what all information can be asked for the inspection of works, documents, records, taking notes, obtaining information in the form of tapes, video cassettes, all of these things, right? This can be done. All of this information can be asked by the citizens from the public authority. So the public authority, when we are talking about, it can be by the constitution, it can be made by the constitution, under the constitution, or by any law made by the parliament, any other law made by the state legislature, a body owned, controlled, or substantially financed by the appropriate government, a non government organization which indirectly is funded by the appropriate government. So, these are all the entities from which the citizens, people, they can ask for information or they can demand a right to information, right? Next act is the right to information. Under this, we have the public information officers. These are the officers that are designated by the public authorities in all administrative units or officers under it to provide the information. So, whenever a citizen makes a request for the information under the act, it is the responsibility of the public information officers to provide this information. And as per the right to information regulation of fee and cost rules, the application shall be accompanied by a fee of rupees 10. So the citizen can file an application demanding the information, and the fee that they need to pay will be of rupees 10. This is under the right to information regulation of fee and cost rules 2005. Now, where the application is received by another public authority or the information is closely connected with the function of another public authority, like let's say the citizen has filed an application to the central government, but the information is related to some state government. So, application will be transferred to that public authority within 5 days from the date of receipt of the application, and they will inform the applicant about the transfer as well. Again, fill in the blank type question. In how many days does the public authority transfer the application if it is related to the functions of another public authority? 5 days. Also, they have to inform the applicant about the same. The request for information, however, can be rejected where such a request for providing access would involve an infringement of the copyright subsisting a person other than the state. So, other than the public authority, if the particular application or the request of information is for providing access to some confidential information which might lead to infringement of the copyright, then such request will be rejected. It is not important that the public information officer they cater to each and every request, right? And the acts that are certain categories which are exempt for disclosure is provided under the section 8 of the statute. The section 8 tells us that which type of information will be excluded or it will not be provided. So the information or disclosure which would be prejudiced towards any particular in integrity and the sovereignty of India, scientific or economic interest, information which is forbidden to be published by any court of law, or which would lead to breach of privilege of the parliament, and it would be information including the commercial confidence, trade secrets, or intellectual property. So all of these information can be rejected. All of this information can be rejected. Now the central government has the power to constitute a body that is known as the Central Information Commission. State governments can form the State Information Commission. The Central Information Commission has the power to impose a penalty of 250 rupees for each day. Okay, now what happens? What is the penalty? If any public authority, after receiving an application for the right of information, they are not providing the information, or they're providing misleading information, or the person complaining they're not satisfied that they're that they've been given the correct information. So for that delay, the Central Information Commission can impose a penalty of 250 for each day till the information is furnished, subject to a maximum of 225,000 rupees. All right. So the for this, every public authority shall maintain all its records related to the resources. They should be computerized and connected through a network that can give access to such records. We know the e-governance portal where the information can be provided on the portal. Then the particulars of the organization, functions, duties, the powers and duties of the officers and the employees, or the norms that are set by the for the discharge of its functions, the directory of its officers and employees. So the public entity requires it is required for them to keep records of all of this information, right? What is the procedure? The PIO, they shall deal with the requests from the persons that are seeking information, and the request cannot be made in writing. Where the request cannot be made in writing, they have to provide a reasonable assistance so that they can reduce the same. Then the information that is requested, if it is related to another authority, it will be transferred within 5 days. The PIO may also seek assistance from other officer for the proper discharge of the duties, right? And they have to make sure that in any case within 30 days, within 30 days on receipt of the application, they provide the information, or they will have to pay the fee that is prescribed, or they can also reject the request for the reasons that we just stated, right? And with the information, where the information is requested for concerns of, let's say, life or liberty of a person, then the same information shall be provided within 48 hours. So this provision was also there. Normally within 30 days information has to be provided. If it is a case of uh, personal liberty or related to the life or death of the person, then within 2 days 48 hours the information has to be provided. Then disposal of request. When the request is being rejected, the PIO should communicate to the requester as well the reason for such rejection, why the request is being rejected, the period within which an appeal against such rejection may be preferred, also the particulars of the appellate authority, right? Then regarding the payment of fees, we have already seen rupees 10 has to be paid according to the right to information regulation and fee regulation of fee and cost rules of 2005. Disposal we have seen for the reason. Then the application that are to be made, rules are regarding that also for third party information, rejection of the request for the information that is kept exempt from disclosure. We have also discussed those areas. If we talk about the appeal, so if a government authority they are unable to submit a request, they are unable to furnish the information, and this makes the applicant unsatisfied, they can file an appeal, right? So the people who have been refused access to any information, who have been given a response to who have not been given a response to the request, and who have been required to pay a fee which the person they consider it unreasonable, or they believe that they have been given incomplete, misleading, or false information, right? So they can make an appeal. They can make an appeal, and penalties will be provided. The Central Information Commission they will impose penalty as stated of 250 rupees per day till the maximum of 25,000 rupees until the information is furnished. All right, so these are the provisions. Also, the commission can take disciplinary action against the Central Public Information Officer if they are not providing the information, they're not providing the reasonable cause why the information is being delayed. If knowingly they're giving incorrect information, incomplete or misleading information, or they're destroying the information which was the subject of request, and so on. So these things we can make out on our own, that yes, the Information Commission officer has the powers and responsibilities. Next act is the Information Technology Act of 2000. The Information Technology Act of 2000. This act was enacted, or was came into force after the General Assembly of the United Nations. They made a model law on the electronic commerce. It was adopted by India as well. Therefore, taking into account the model that was appointed in 2000, both the houses of the Indian Parliament they passed the Information Technology Bill. The cyber laws are also contained in this act. The cyber laws are also included in this particular act. So this act aims to provide the legal infrastructure for e-commerce, which involves the use of alternatives to paper-based methods for storage and communication of the information, to facilitate e-filing of the documents of government agencies, right? So if we look at some of the definitions, the appellate tribunal under the Act is the Telecom Disputes Settlement and Appellate Tribunal, which is established under the Section 14 of the Telecom Regulatory Authority of India, 1997. And from the commencement of Part 14 of the chapter, the Appellate Tribunal for the purpose, and the said Appellate Tribunal shall exercise the jurisdiction. So, what we need to remember from here is, what is the Appellate Tribunal under the Information Technology Act? It is the Telecom Disputes Settlement and Appellate Tribunal, not RBI, not central government, not any other authority, but the Telecom Disputes Settlement and Appellate Tribunal, right? This is established under the section 14. Okay, next, the electronic governance. Chapter 3 deals with electronic governance, gives legal recognition to the electronic records and the electronic signatures, including the government and its agencies. Here, the sections are mentioned. If you already know about the sections, well and good, perfectly fine. If you do not, don't worry. If you do not, don't try to learn anything new, don't take in any new information. All right, if you already know, that is fine. So it also deals with the delivery of services by the service providers, used for the efficient delivery of services in the electronic form by the government. So basically everywhere or every area where the technology is involved in providing the services, it will be covered under the Information Technology Act. So access, then addressee means the person who is intended by the originator to receive the electronic record. Then adjudicating officer will be the officer appointed for the delivery of the duties, right? Then what else is there? So the aggrieved person, by an order, they can make an application to the controller or the adjudicating officer. They can prefer to appeal to the appellate tribunal also, that is having jurisdiction in the manner. Um, the computer resource, data, everything we already know. Electronic governance, the information contained, it should be accessible so that it can be used for a subsequent reference. Electronic record should be accessible to the common public also. The information that is required regarding the programs and schemes. Then the data that can be provided regarding the certifying authorities, exercising the supervision over the activities of the certifying authorities is with the controller. Then the certifying public keys of the certifying authorities. I don't think anything here is of much importance. If we talk about the investigation, so who has the power to investigate the various offences? The chapter 11 of the Act lists various offences and how the said offences will be investigated by the public officer not below the rank of inspector of police. So who is assigned the responsibility of conducting the investigation of the various offences under the Information Technology Act? It is a police officer not below the rank of the inspector of police. So these offences include tampering with the computer source documents, publishing information which is obscene in electronic form, and hacking. So these offences are investigated by the police officer not below the rank of the inspector of police. Also, the Act envisages a controller of the certifying authorities. Now, what will be the function of this controller? To perform the function of exercising supervision over the activities of the certifying authorities. They will lay down the standards and the conditions. Also, they will specify the various forms and contents of the digital signature certificates. So all those certifying agencies that are certifying that this information is correct, what all conditions and terms they have to follow, this is supervised by the controller. The controller of certifying authorities, the name itself suggests, the name itself suggests related to the digital signature certificates also. Then regarding the penalties, if we talk about, so if any person without the permission of the owner or any other person who is the charge of the computer or computer system, they access or secures the access to the computer for some illegal use or fraud, they download the copies or extract data which was kept confidential, they introduce or cause damage to the computer or the data, they deny the access to any person authorized, that is their hacking, they're stealing, concealing, destroying the information, so they are liable for penalty under the law. So the Act provides for the appointment of any officers not below the rank of director to the Government of India. The director to the Government of India, they can take provisions, they can adjudicate whether any person has made a contravention. And the said adjudicating officer has been given the powers of a civil court. So their decisions will be the decree of the decisions taken by the civil court. If regarding the appeal, then the appellate tribunal, they shall receive the appeals that are made by the person. We also have the central information infrastructure, which is a protected system. The documents of the transaction, where the act will and will not apply. Again, too much unnecessary, irrelevant information that we need not revise today. And finally, we move on to the last act of our syllabus, which is the Prevention of Corruption Act 1988. It was This was legislated with the aim to combat corruption and other misconducts mainly by the government and public enterprises, including the public sector banks. Even the public sector banks are included under the Prevention of Corruption Act. All right. So, Section 3 of this Act gives powers to the central and state government to appoint the special judges. Question was asked in the previous examination that who or which of the following is has the power to adjudicate or preside over the cases related to the Corruption Act of the public authorities. It is the special judges. So they are allowed to try the cases under the particular act. As per section 13, a public servant is said to commit the offense if he dishonestly or fraudulently misappropriates or converts for his own use any property entrusted to him or any property under his control as a public servant, or allows any other person to do so if he intentionally enriches himself illicitly during the period of his office. So we already know what is the meaning of corruption. If the public authority, if the officer, they're using their power to perform some illegal activity, or they're trying to elicit money, or they're giving some prejudiced, let's say, advantages to another person using their power, then all of this will come under the offense of criminal misconduct, right? The criminal misconduct. Now if we talk about the special judges, so special judges are going to try the cases, and the minimum qualifications regarding their appointment, they are given under the act, which are necessary for the appointment. The cases which are can be tried, or the cases which cannot be tried, are given under the act. So the cases that may be tried, not anything contained in the code of criminal procedures or every offense that is given in the act. Then for the transfer of suits in a situation where one of the parties in the trial, they require it to be transferred to another court, that can be done. So all of these things are there. If we talk about the offenses and penalties, like let's say when the public servant was bribed, then the person will be punishable with imprisonment. If the public servant is taking undue advantage, or if the person is giving promises to give undue advantage, then offense relating to bribing a public servant, then charge of commercial organization, many offenses are given under the act. These are the offenses, and the penalties are given from section 7 to section 15. Section 7 to section 15 of the act. We have already seen the section 13 that tells us what is the criminal misconduct. Then we have section 17. The persons authorized to investigate have been specified. The persons authorized are no police officer below the rank of. In case of the Delhi Police Special Police Establishment, the officer should be of the rank of Inspector of Police. In case of an assistant commissioner of police, then in the case of metropolitan areas of Bombay, Calcutta, Madras and Ahmedabad, or any other metropolitan area, then this should be the position of an assistant commissioner, and elsewhere the position should be of a deputy superintendent of police or a police officer of equivalent rank, right? So three cases are given. In the case of Delhi Special Police Establishment, position of inspector of police. In case of metropolitan areas, the assistant commissioner, and anywhere else, the police officer of the rank of deputy superintendent will be authorized to investigate the cases. Section 18 gives powers to a police officer who has the reason to suspect that for a purpose of investigation, inquiry, it is necessary to investigate the banker's book, they can do so. So section 17 also gives the power to the police officer that they can inspect any banker's book if they have enough reason to suspect that certain misconduct is being conducted, right? If we talk about the fines and the penalties, so section 16 says that fine, the often offense that are referred to in the clause from section 7 to section 15 that are defined. Accordingly, fines can be done, like punishable for a term period, and fine will be given. Then the persons who are authorized to investigate, we have already seen. inquiry related to that, the power to inspect the banker's book, all of these things are there. Regarding the appeal and revision, so appeal and revision in the judgment of a special judge under the act normally lies with the High Court. Normally lies with the High Court, and it is brought out by section 27. Again, very important, if you are asked which of the following or the appeal and revision in the judgment of the special judge under the act normally lies with which of the following, so it is the High Court. And that is all. We have completed all the 4 modules, all the 25 acts in these modules, contained in the modules, and that is all. You need not worry that you need to study in detail or you need to go through all the videos or MCQs or anything. Have faith in your preparation. You have given your 100%, right? And now when you go for the examination, nothing will be asked out of this. Nothing at all. If you still want to revise in the morning before your examination, you can download the PDF. If not, then also it is fine. Simply have faith, believe in yourself, believe in your preparation. You have followed each and every step, you have seen the videos, you have practiced the mock test, you have seen the MCQ videos, their explanation, and that is enough for your preparation. Now I will meet you tomorrow after your exam, and I would want all of you to come and tell me that you have qualified the exam, your marks that you have secured. I'll be waiting for your response. If you have any doubt, any query, if you want to let me know anything, please let me know now. Otherwise, take proper rest. Don't keep yourself awake for the whole night. Take rest so that your mind will be fresh when you wake up for the examination. I wish you all the best, all the good wishes, and I'm praying for your success in tomorrow's examination. Thank you for attending the session. I will see you tomorrow after the exam in the exam analysis.